afternoon, Justice Molemela.
Good afternoon, Chief Justice.
How are you this afternoon?
I think I'm fine, Chief Justice.
You are not sure?
I'm not sure. I think so, though.
You think you'll only be sure after the interview?
I think so.
Yes. Thank you very much for coming to this interview, Justice. You were nominated by the President of the Republic as his nominee for the position of President of the Supreme Court of Appeal, which nomination you accepted, and we are happy that you are here. You have submitted a questionnaire and attached some judgments to it. In addition, this morning in a meeting was to adopt criteria for the appointment of candidates for positions of judges in the superior courts. And part of what the document says that contains the criteria is that we will be robust when we question candidates, but at the same time, we will have due regard to the human dignity of the candidates. We'll show respect, we'll show courtesy. So we'll seek to strike a balance. So I can assure you that there is nobody here among the commissioners who wants to do anything other than simply seek to strike that balance in the best way that they can. There is nobody here who has come with an intention to show you disrespect or anything of that kind, or to treat you unfairly. But at the same time, it's important that candidates for judgeship some questions, and at some stage I will give you an opportunity of about 15 minutes for you to share with the commissioners what you might wish to share in terms of what challenges you are aware of that face the Supreme Court of Appeal, and how you propose to deal with them if you were to be appointed as the President of the Supreme Court of Appeal. And after that, I will allow the acting President of the Supreme Court of Appeal, Justice Spencer, to put questions to you, and thereafter the Minister, and after that, everybody. So that is how we are going to go about this.
Thank you, Chief Justice. I understand. Thank you.
Thank you. Thank you. Would you like to begin by sharing with us telling us your academic qualification? 1 second, Justice Molemela.
Yes.
I don't know. I feel like I can't hear you well. Maybe you are
Let
too
me
far.
bring the mic closer.
But I wonder whether even the table could be brought a little closer. I don't know. How do you hear? Do you hear well? Yeah. Okay, maybe you can try and raise your voice. If that doesn't work, we will ask that maybe your table be brought closer if possible.
Yes. Thank you, Chief Justice.
Okay, can I ask you to just give that answer again?
Yes. The degrees.
You can tell us the degree,
Yes.
when you got it, and which university.
Yes, the degrees are Bachelor of Arts obtained at the University of Fort Hare, BProc also obtained at the University of Fort Hare, postgraduate diploma in advanced labor law obtained at the University of Johannesburg, Bachelor of Laws, LLB, obtained at the University of the Free State, postgrad diploma in business obtained from the Buckinghamshire Chilterns University College, Master of Laws, LLM, obtained from the University of the Free State. And the diplomas are as follows. Diploma in Advanced Military Law, obtained after successfully attending a course and writing exams at Tabatswani Military College. Sorry, DCJ. For some reason, I can't find the relevant page in the,
Yeah,
that has all the.
Okay,
all the
anyway, we've
degrees
got
and
it here.
diplomas. Yes,
yeah,
sorry about that.
yeah, okay, no, that's fine. I understand why you have to look, there are just too many. Now, you started your legal career as a candidate attorney and then as an attorney. Is that
Yes, Chief
correct?
Justice. That is correct, Chief Justice.
How many years did you practice as an attorney before you were appointed as a judge?
I was admitted in 1995. 1990. Sorry, Chief
89?
Justice. 1990. I was admitted in 1993, yes, and appointed in 2008. So that would be a total of 15 years.
Okay, well, I see that here you have candidate attorney and attorney 1989 to 1995.
Yes,
So the actual admission as an attorney would have been 90, did you say 3?
1993, Chief Justice, yes.
Oh, okay.
I'm just give me a moment, please, Chief Justice. Let me just check here.
On page 3 of your volume, your bundle, item 6.
Let's move to that page. Yes, and I was admitted in 1993, Chief Justice. But I don't want to give you wrong information. I just want to make sure from, yes, admitted as an attorney. I see on page 6, under professional history there, it states admitted as an attorney in 1993.
Okay, okay. And your appointment as a judge, was it in 2008?
In 2008, Chief Justice, yes.
That was now an appointment as a judge of the Free State Division of the High Court.
Yes, that was an appointment as a permanent judge of the Free State High Court, having commenced acting in that court in 2005, but on an ad hoc basis.
Before you got appointed as a judge, while you were in practice as an attorney, are there leadership positions that you may have occupied?
Yes, I occupied leadership positions in the very firms I was involved in. There was a time when I practiced for own account and several times when I practiced in partnership. So I would say my leadership positions commenced in 1993 when I was admitted, when I became an attorney. In 1995, I opened my own practice and was in charge of it. And I think in 1996, entered into a partnership. And ever since then have been in, I was in partnerships until I was appointed as a judge. But in all those capacities, I was fulfilling leadership functions as a director of the firm,
Yes,
partner / director of those firms.
yes.
I was also a councillor or a council member of the Law Society of the Free State, which also is a leadership position within the profession. I was a development member of the Board of Control of the Attorneys Fidelity Fund. I was also a trustee of the School for Legal Practice of the Free State. I've occupied various leadership positions within the legal profession, DCJ, long
Yes.
before I was appointed as a judge.
Yes, okay. Now, you were appointed as judge of the Free State Division in 2008. And
Yes,
then
Chief
when
Justice.
were you appointed as judge president of that division?
In 2015. The interview was in October 2014, and the commencement date was the 1st of January 2015, Chief Justice.
Are there some challenges that you found once you assumed the leadership position of judge president of that division, which you would like to share with the commission and which you dealt with in your capacity as judge president, that you would like to highlight and say these were some of the problems I found in the division once I became judge president, and this is how I dealt with them?
Yes, the main problem was actually flagged at the interviews when various candidates, I think there were 4 candidates, when 4 of us were interviewed for the position, and most of the candidates, including myself, pointed out that there was a challenge in respect of the preparation of the role, especially the term role, and also in relation to appeals, the appeal records being distributed late to judges. There were instances where, unfortunately, an appeal that had to be heard on Monday, the record of that appeal would only be sent to the judge maybe on a Thursday. So those were the main problems. So I would say the main problem really related to the preparation of the role. And because that was an area that had been identified and debated quite rigorously at the interviews, I made sure as soon as I was appointed that I rectified the situation. There was a perception that the allocation of criminal cases to judges was discussed with the Director of Public Prosecutions, and that the Director of Prosecutions actually sometimes indicated the judges that they would prefer hear the matters. So there was a dissatisfaction among colleagues regarding that aspect, because we held the view that the Director of Public Prosecutions had no business in making any contribution as to which judge had to be allocated the case. So that was the first thing that I attended to. I called the delegate of the Director of Public Prosecutions to inform her that going forward, I would not be asking them to indicate to us which judge they wanted allocated to the matter. And the problem was amicably resolved. I adopted a very hands-on approach in relation to that and kept in constant contact with the Director of Public Prosecutions regarding cases that needed to be expedited, for example, where an accused person in a case that had multiple accused persons, decided to plead guilty. That case would be expedited at very short notice to ensure that the trial would proceed without having to be postponed. So that meant having, being in constant contact with the DPP's representative. At that stage, it was Advocate Elsa Smith, I think. And we had an arrangement that during tea time, she would phone me to inform me of any urgent matters that had cropped up and that needed to be placed on the roll. So although at first there were a few tensions because of the manner in which I wanted us to handle the matter, in the end, within a few weeks actually, all the kinks in the chain had been smoothed out and everything was going very, very well. And we had a very good relationship. And I must say that although she left Bloemfontein a long time ago and I left the High Court a long time ago, we still sent each other messages, like Christmas messages and on special days and so forth. So an initially difficult relationship turned into a friendship much later. And the other challenge that we had, which affected the enrollment of cases, was that we had a lot of cases coming from the Eastern Free State. And at that stage, we only had 2 circuit courts in the Eastern Free State, in Harrismith and in Bethlehem. And I realized that there were many, many instances where the witnesses could not reach Harrismith in time because they were traveling from Putadichaba to Harrismith or from Putadichaba to Bethlehem. And even the relatives of the victims and the accused persons sometimes could not make it to the court. So I made inquiries, and because I knew that there was a fairly new child justice court that had been constructed in Putadichaba, I contacted the relevant persons to inquire how often that court was being used. And we came to an arrangement that I would, at the end of each term, submit dates on which I would like to use that court as a circuit court. And they too would indicate the dates on which they had scheduled cases for child justice court matters. And so there was a symbiotic relationship where the same center was used as a child justice court and also as a circuit court. And it worked very, very nicely. And it reduced any backlogs that were there in the system. The same applies to the other part of the Free State. I noted when I was doing cases in Virginia, which was our circuit court, that on many occasions the court would be empty. And I would wonder why the court is empty, because the accused person has relatives and the victims also have relatives. And when I asked around, I was told that it was because the offense had been committed in Velkom. So the case emanated from Velkom, and many of the parties involved, the witnesses and the accused relatives, did not have the money to travel to Virginia for the trial. I made inquiries and facilitated the provision of a circuit court in Velkom. There were a few challenges regarding the layout of the court, and the Department of, the DPW, Department of Public Works was involved, and they made structural changes. And as we speak, 2 courts are being utilized in Velkom for circuit court purposes. So those are the ones that I can immediately think of. Oh, okay, and there was a stage when we lost 5 courts simultaneously because a section of our court was being repaired. It was in a state of disrepair. And DPW, Department of Public Works, gave us an estimation of how much time it would take to fix the problems that were there. And it turned out that they had actually grossly underestimated the time of completion. So not wanting our court to end up in a backlog because we could not utilize 5 courts, I contacted various magistrates' court, and the magistrate the chief magistrate in Bloemfontein gave us 1 court in the magistrate court, which we used. And the magistrate also gave us 1 court in Botshabelo. Incidentally, a lot of cases that were being heard in Bloemfontein emanated from Botshabelo. So it was also convenient for the community of Botshabelo because then the witnesses and the relatives of the accused persons and the victims could travel to court easier. But more importantly, we never developed the backlog despite the fact that 5 courts had not been made available. And because 5 courts were not available, 5 chambers were also not available. So colleagues were prepared to share, and the Department of Public Works was also prepared to offer us 2 rooms because it's situated right across the court. So they gave us 2 offices that we used as chambers. So I would think that that was a very creative way of attending to the problem.
Yes, thank you very much. Your CV reveals that you have acted in a number of courts, or you have even been a member of other courts other than the High Court and the Supreme Court of Appeal. You acted in the Competition Appeal Court. Were you appointed as a judge of the Competition Appeal Court, or you only acted?
No, I only acted. I think I acted for 2 years.
For 2 terms?
For 2 years.
For 2 years?
Yes, Chief Justice.
And you acted in the Labour Appeal Court, but you were ultimately appointed as a judge of the Labour Appeal Court, is that correct?
That's correct. I acted at the Labour Appeal Court for 2 years and was appointed as on a 10-year contract.
Yes.
Yes, 2 years later.
And your 10 years expires next year?
It expires next year.
But I assume since you went to the SCA, you have not been performing any duties in the Labour Appeal Court?
Regrettably, yes, I haven't, Chief Justice.
Okay. But you also acted in the Constitutional Court for 2 terms, is that right?
That's right, Chief Justice.
Yes. And the Land Claims Court, have you acted there as well or not?
No, I haven't acted in the Land Claims
Yes.
Court.
But I may be missing out one or other court in which you have acted, because your CV reveals that you have really been involved in a number of courts. Have I covered all of them?
Yes, it's the
Competition
Labour
Appeal
Appeal
Court,
Court, Competition Appeal Court,
Labour Appeal Court,
the Supreme Court of Appeal,
and Constitutional Court?
yes. So I acted in all the appellate courts.
Yeah,
Yes.
yeah. And your appointment to the Supreme Court of Appeal, that was in 2018, is that right?
That is correct, Chief Justice.
So you have been there as a member of that court for about, what, 5 years?
Almost 5 years, yes.
Almost 5 years,
Yes, Chief Justice.
And have you enjoyed it a lot?
A lot. I enjoy the intellectual challenge there.
Yeah.
Yes.
But of course, we do know in this commission that you also wish to be in the Constitutional Court, and you made yourself available.
That's correct.
It didn't happen, but you had acted there, and
That's correct.
you're in the Supreme Court of Appeal. Now, I would like to give you now the opportunity to share with the commissioners what you have identified as challenges that the Supreme Court of Appeal has. Of course, you can tell us if there are no challenges, and how you propose to deal with them if you were to be appointed as president of that court. I'll give you 15 minutes.
Yes, thank you, Chief Justice. I have prepared something in writing because I had a feeling that if I had to speak of the calf, I would take 3 hours to go through this. I must point out, Chief Justice, at this point already, that although I am going to give the Commission priority, 7 areas that I consider to be my priorities in that court if I am appointed. I must just acknowledge this important fact that I inherited a well-oiled machine when I joined that court. But as the saying goes, there's always room for improvement, and it is in that context that I am making suggestions as to how we can try and make improvements at the court. It should not be considered as me saying I'm finding the court in a condition that is not good and I am now going to be implementing new changes. So I will be there to introduce a few changes and to make improvements.
Yes, okay.
May I also, please, Chief Justice, just ask you for an indulgence in case I overrun?
Yeah, no, that's fine. I will keep an eye on the watch.
Yes, thank you. I've divided my vision for the Supreme Court of Appeal into the following 7 segments of priorities, Chief Justice. Implementation of strategic leadership to promote trust among colleagues and boost the morale of the entire workforce of the SCA. Allocation of cases and designation of scribing duties to colleagues. The 3rd priority is the capacitation of the research function to enable that court to continue complying with the performance standards envisaged in the published norms and standards. The 4th priority would be a court modernization and capacitation of the General Office. The 5th would be the optimization of acting appointments. The 6th would be responsiveness to issues that are raised by court users. And the 7th would be placing important items on the agenda of the heads of court, should I be appointed. And just by way of a few introductory remarks, I must just mention, Chief Justice, that I accepted the nomination because I believe that I have the necessary leadership skills to lead the SCA. I've had, as you correctly mentioned, the distinct privilege of having acted in all the appellate courts in South Africa. At the time when I was acting in those courts, I observed how things were being done and was impressed by how well the courts in question were being run. And when I was appointed as the Judge President of the Free State High Court, I adopted the best practices from all those other courts and obviously had to make a few adaptations here and there. So I'm happy to say that I had already learned from the best when I was appointed as the Judge President. I, however, Chief Justice, did not become complacent after my appointment, and I was always striving to effect improvements at the High Court. On numerous occasions, I would often use the public entrance of the court, Free State High Court, just so as to get an impression of what an ordinary court user visiting our court, what the impression they formed about our court, or what impression it gave about our court. I also very frequently visited the General Office for the same reason, to, asking myself, if somebody is coming here for the first time, what are they seeing? Are they seeing an organized organization, well run, or are they seeing chaos everywhere? And I must say that we were consistently receiving compliments, especially from counsel coming from other divisions, who were complimenting us about how well the court was run, especially about the turnaround time in relation to our cases. And I consistently shared those compliments with my colleagues because I knew that it would motivate all of us to try even harder. I would also want to, at this stage, Chief Justice, and it's important that I mention that the congratulatory messages that I received from far and wide after the news of my nomination, sent by colleagues from all the courts where I had been involved, but more importantly, also sent by the support staff members, really humbled me. I have received messages of support from all my colleagues at the SCA, and the vast majority of them have assured me that I have their support and they are prepared to work with me and they will support me. But more importantly, especially coming from the ladies, it means a great deal to me that all of them, in one way or other, had warm words to say about this nomination, telling me that they would, not only that they would support me, but that they were actually proud that I had been nominated for this position. So, but by far the cherry on top, I think, was the message that I received from the acting president of that court, Deputy President Petse, in which he expressed the trust that I will, and I quote, steer the court in the right direction and even to greater heights, unquote. So, Chief Justice, my peers from all over, from all levels of the profession, of the legal profession, have given their thumbs up. The law bodies have done the same. My first priority, which is the implementation of strategic leadership to promote trust among colleagues and boost the morale of the entire workforce of the SCA, will be as follows. Informed by the collegiality that reigned supreme from the time I started acting as a judge of the Free State High Court in 2005, 18 years ago, I concluded in those early days already that the success of any court depends heavily on collegiality of its bench. And this belief was fortified when in 2014, the norms and standards were published incorporating a clause that enjoins heads of court to foster and encourage collegiality among colleagues. And the Judicial Code of Conduct too considers collegiality as one of the indispensable attributes of a judge. I have never forgotten, Chief Justice, how when I was being welcomed as a judge, not a judge president, a judge of the High Court in 2008, in a ceremonial court sitting, the representative of the Law Society, Mr. Henry van Rooyen, mentioned in court, on record, that he knew that I would perform my functions as a judge very well because I had performed very well as a council member of the Law Society. And he made specific mention to the fact that I always stood for the truth, and also mentioned that they knew as members of the Law Society that if they asked for my opinion on anything, it would be an opinion that would be well considered. I, up to that stage, had not realized that I had those special qualities, and once they had been mentioned, I only sought to improve. And so that is how I have conducted myself throughout, since my appointment as a judge. I continued to stand for the truth in the Free State High Court. Even after my appointment as a judge president, I have stood for the truth in the Supreme Court of Appeal. I have considered all the matters that were allocated to me. I have prepared very thoroughly for my cases. I have worked very hard, put in long hours, very often knocking off at 10 at night to make sure that I was well prepared.
Molemela, I'm sorry about what happened. You
Yes.
were interrupted while you were making your presentation.
Yes, thank you,
But,
Chief
but
Justice.
if you can continue from where you left off.
Yes, thank you, Chief Justice.
Yeah.
The reason why I'm giving all that background to my leadership style is just to illustrate, Chief Justice, that I will be able to implement strategic leadership at that court and to promote the trust among my colleagues, not only my colleagues and the entire workforce and our external stakeholders, counsel, litigants, and so forth, and that I will boost the morale of the entire workforce of the SCA. One thing that I also must highlight, Chief Justice, is that as a judge president, I had functions that were given to me as head of court in terms of the norms and standards. And that was being or fulfilling a coordinating function of all the courts in the province. And there were about 132, if I'm not mistaken, district courts and about 50-something regional courts. So in addition to my role as being the leader of the Free State High Court, I also had to coordinate the functions of the other courts, and I did that. And it was easy to do that because I held meetings with all the leaders of those courts, the chief magistrates, the president of the regional court. We had monthly quarterly meetings which took place before the meetings of the Provincial Efficiency Enhancement Committee to see the challenges that were facing their courts at that time and to see how we could resolve them. And thereafter, I also had a session with them again at the level of the Provincial Efficiency Enhancement Committee. But despite the fact that I was fulfilling all those administrative functions, I was also allocating my work to myself. I participated in all the cases, criminal trials, civil trials, appeals. I also even did circuit court and recess duty, and I continued doing recess duty until my colleagues unanimously resolved that I should no longer do recess duty because of my other responsibilities. So that's just a demonstration of me just being a leader who considers herself to be a first amongst equals, which is very, very important, and that I will therefore be able to promote trust and collegiality amongst my colleagues. So, Chief Justice, in addition to smooth internal stakeholders that I'm going to try to maintain, I'm also going to extend collegiality to external stakeholders like practitioners who appear in our courts and the litigants. I fully appreciate the importance of maintaining the dignity and decorum of the court. So counsel and litigants must leave the court with an impression that they were given a fair hearing. It is for this reason, Chief Justice, that I will, in line with a resolution taken at our court a few years ago, but which has unfortunately not been uniformly implemented in all cases, I'll encourage my colleagues to consistently offer counsel 10 minutes uninterrupted time within which to make their submissions without being interrupted by the bench, unless, of course, they expressly waive this indemnity. This period can be extended in complex matters. I think it is the very least that the Supreme Court of Appeal can do to dispel any notion that its bench is sometimes commandeering and impatient with practitioners during oral argument. With the aim of achieving the laudable objective of expeditious resolution of all disputes that come to the SCA, I will strive for effective, result-driven leadership that inspires judges to aspire for excellence that the SCA has been known for, and in all the execution of all our functions. I will ensure that my colleagues excel when it comes to executing our core function, the handing down of judgments. But given the challenges that I will mention shortly, I'll have to play a huge role in motivating my colleagues to continue to perform at their best under very, very difficult circumstances. Believing in collaborative, inclusive leadership as I do, Chief Justice, I'll encourage colleagues to participate actively in the committees that have been created at the SCA. In addition to that, I will encourage the chairpersons of committees to convene meetings of committees at least once a term, Chief Justice, and to disseminate the meetings of those meetings, of the minutes of those meetings to all the colleagues. What I did at the High Court in relation to these committees is initially the chairpersons wanted to send me the minutes of their meetings, but I indicated to them that to show how much I trust them, the minutes should actually be sent directly to all the judges. Any corrections that need to be made to the minutes will be made at that forum. And so that is what I also would wish to see happening at the SCA, regular meetings of committees, and the minutes of those committees also being circulated. More importantly, the chairperson of the committee preparing a report for the meeting of judges that is held at least once a term. I will also, if appointed, organize a follow-up diversity training just to round off on the previous diversity training that we had, Chief Justice. As a trustee of the South African chapter of the International Association of Women Judges, I am also aware that the trust will in due course be rolling out a social context workshop for judges at a continental level. I will encourage the judges of the Supreme Court of Appeal to also attend that workshop. I will also, because judges too experience trauma, grief, and other challenges in their lives, which may overwhelm them for a period of time and possibly have an adverse effect on the performance of their functions, I will consult with my colleagues for purposes of introducing a fit-for-purpose wellness program for our court, focusing on promoting physical, mental, and emotional health and personal security of all the colleagues. The wellness program will be implemented on an ongoing basis so as to also prevent burnout that may be occasioned by the stress of having to deal with a heavy caseload. A team building workshop for support staff is also essential at this stage, as are the policies on workplace bullying and sexual harassment, which have, in a survey conducted by the International Bar Association, being identified as one of the problems faced by 1 in 3 persons at all levels of the legal profession. These measures, Chief Justice, which should be funded from the court's training budget, are crucial, given that judges and support staff spend hours on end in a working environment that is very unforgiving and that is by its nature isolating and highly stressful and should not be exposed to any toxicity in the workplace. A harmonious working environment is integral to the success of any organization. I would, as my second priority, be involved in the allocation of cases and designation of scribing duties.
May I just interrupt you so that you have an idea of how the time is?
Yes.
If we stick to 15 minutes, you would be left with 5 minutes.
All right, I'll try to be short, Chief Justice.
So I just mentioned that, yeah.
Yes.
But
So
I do want you to
yes,
deal with
to stick to
important
the time.
issues. Yeah.
Yes. I have in the past 5 years that I've been, that I've served as a justice of that court, always prepared thoroughly, as I mentioned, Chief Justice. So I will be in a position to play the role as the leader of the court who prepares the role and who allocates cases for judges. And in doing the allocations, I will, like my predecessor, make sure that there's a spread of complex matters to all the colleagues. And most importantly, I will also ensure that, there's a spread also in terms of scribing duties. And that will result in a transfer of skills. And in doing that, I will allocate, designate 2 scribes, or sometimes if it's a voluminous record, designate 3 scribes for a particular case. And I also want to mention that that should not worry anybody, because in any event, all appellate courts are collegial courts, and every single judgment that is produced actually incorporates the views as much as possible of the other colleagues. So co-scribing will be useful in that sense. My third priority, Chief Justice, is the capacitation of the research function to enable the court to continue complying with performance standards envisaged in the published norms and standards. This is a very important one, Chief Justice, because at the time, at this point in time, we have an inadequate number of researchers. And the research function is very, very important. Any article that you read on the research function at the courts will show just how important it is, Chief Justice, that an appellate court should have sufficient researchers that will test the judgments that are sent to the researchers for editing to see whether they comply, whether they contain everything that is necessary before they are circulated to the colleagues. We have 6 researchers at the moment, and I think they are inadequate. This has been discussed at the meetings of judges, and we are all agreed that the number is inadequate. We have been unable to engage more because of budgetary constraints, and it's a serious problem, Chief Justice. There was a stage a few years ago when we had interns, and this was facilitated by the South African chapter of the International Association of Women Judges. And for about 3 years, we had 4 interns doing the research function in addition to the complement that we had. Unfortunately, the funds dried up, and now we are reliant on the complement that we have. I have compared this, and I don't want to compare the SCA to the Constitutional Court, but I do have to mention that just to highlight the seriousness of the problem, that whereas at the Constitutional Court, each chamber is allocated 2 researchers. At the Supreme Court of Appeal, 4 judges are allocated 1 researcher, which is grossly inadequate by any standards in the world for an appellate court that is as important as the Supreme Court of Appeal. So I would, of course, implore the department to provide the SCA with more financial resources, Chief Justice. The other serious problem that we have, in addition to this one of the research function being limited, is that we don't have, since 2019, our library is not being updated. We don't have law reports in our chambers. Our chamber libraries are not being updated, and this, we are told, is because of financial constraints. So I will, if appointed, once again approach the South African, in addition to approaching the department to provide the SCA with funding. I will also approach the IAWJ, South African chapter of the IAWJ, to see whether they cannot once again try and get into partnerships that will enable the court to have more interns from various universities. And there's a faculty of law at the local university, and I think they will be more than pleased to assist. Chief Justice, several challenges were raised about the state of service rendered by the General Office. Those have been attended to. Additional staff has been employed. The Office of the Registrar has been beefed up, in addition to measures that are in place just to make sure that the systems are beefed up or tightened up a bit. I will also introduce that we have a chamber book in which the applications for expedition of appeals will be registered. This will help us to always be mindful of the pending applications, and that no application for expedition is not attended because the file has been misplaced or things like that. I will also optimize acting appointments, Chief Justice, and I must also mention at this stage that we are at a stage where we have 19 permanent judges. Our full complement is 25 judges. Amongst the 19 permanent judges that we have, 12 of them are women and 7 are men. So we have gender parity at the Supreme Court of Appeal, but my priority will be to ensure that we don't go back to a stage where there is no parity on our bench. And on this one, I just want to pause to acknowledge that this interview, Chief Justice, is taking place against the backdrop of the 100 more campaign celebration of the promulgation of the law that entitled women to practice law. Just as a matter of interest to other commissioners, to mention that in 1912, a lady by the name of Wuki wanted to become a lawyer, went to a firm of attorneys. The firm of attorneys was prepared to enroll her articles, and when they tried to register with the Law Society refused. The reason being that a woman could not be admitted as a lawyer because she did not fit into the definition of the word person as set out in the applicable legislation at that stage. The irony of ironies is that whereas one judge of the Cape Division had made an order ordering the Law Society to register that lady's articles, the Law Society appealed against that decision to a full bench, and surprisingly, the full bench upheld the appeal, and because of that, the lady could not register her articles. So in a strange twist of events, you find the Law Society and a court of law actually legitimizing patriarchy, which is why we all along we've had a problem of women lagging behind because there was an institutionalized exclusion of their participation. Chief Justice, I'm about to conclude. I just want to point this one out because I think it's important, just to indicate my responsiveness to the needs of the internal and external stakeholders. I'd just like to mention that I've noted that council do their consultations in the courtyard when they are at our court because there's no consultation room for them. It works well when it's not raining, but when it's raining, the courtyard is not weatherproof. They don't have a place to consult. I'll see to it that an office is made available to them for purposes of consultation. I will also, having noted that the support staff do not have any space where to enjoy their tea and so forth, make sure that provision is made for that, to try and see to it that they too get a tea room like in the other courts that where I have acted. For example, at the very Free State High Court, we have a separate tea room for the support staff. And last but not least, Chief Justice, I would have engagement with other heads of court. My engagement with other heads of court is I will place matters on the agenda of the heads of court meeting to see to it that issues that concern us are discussed. And one of those would be the community involvement of the judges. I would want that to be included as an agenda item so that the judiciary can agree and resolve on a structured way in which it will be involved in the community in terms of, making the Constitution an instrument that is not, how can I put it, Chief Justice, that is, the Constitution is a very, very important document. It is the supreme law of the country. We talk about it every day, but many people do not know what is contained in the Bill of Rights. So a structured way would be for the judiciary to maybe consider having a panel of judges that will speak on the radio on the Bill of Rights or at schools and things like that. So those are things that will be discussed at that meeting. And as I conclude, Chief Justice, I just want to assure all of the commissioners that if appointed, I will run the court successfully. I will devote 100% of my energy and passion to ensuring that the court maintains its status as a seat of the jurisprudential excellence. And in relation to the issue of acting judges, just quickly to mention, when I talk about optimizing acting appointments, to acknowledge that the court has lost a number of experienced judges because of attrition, and that this is an aspect that will be taken into account when colleagues are being invited to come and act at our court. Thank you, Chief Justice.
Thank you. I gave you more than
I
had
know.
said.
I thank you for the indulgence, Chief Justice. I appreciate it.
Now, when you shared this with the commissioners, speaking for myself, I did identify maybe one or two areas, maybe three, which I thought you may have been saying they were problems. In regard to some, I wasn't sure whether you were saying they were problems. And part of the reason why I wasn't sure about that was that you did say if you are appointed, you would be inheriting a well-oiled machine.
That's correct, Chief Justice,
Which
yes.
might mean that you were saying there aren't really problems, but there is room for improvement.
Yes, Chief Justice.
So I just want you to make it quite clear to the commissioners if there are problems, and maybe just make it clear which ones those are, maybe three of them, maybe whatever. Or if you say, no, there are no problems, but there's room for improvement, and what I'm talking about is just improving, not that there are problems.
Yes, the one challenge which is a problem, Chief Justice, is the inadequate number of researchers that have been appointed to the court. That is a problem, and it is not a problem of the SCA's making. It is not a problem that we as the judges can resolve. The solution to that problem is to appoint more researchers to assist the judges. This several times, and we were informed that there were budgetary constraints in terms of employing more researchers. So that, Chief Justice, is a problem, and it worries me because the SCA is one of the courts that has been performing very well consistently over the years. And I do not want us to drop the ball, but that is one area of weakness that can result in that happening, Chief Justice, that can affect the quick delivery of judgments, for example.
Okay, at least that was one of those that I had recognized as.
Yes,
what
the
you were saying
others
problems.
are just areas of improvement, Chief Justice.
Okay, all right. You have written a lot of judgments and some are reported. You have got all of that here. But at this stage, I'm going to give the acting president of the Supreme Court of Appeal the opportunity to ask you questions. Justice Betzer.
Thank you, Chief Justice. Good afternoon, Judge Molemela.
Good afternoon, Acting President.
Just by way of comment, I gained the impression that you battled somewhat to tell us when you were admitted. Just speaking for myself, that day was an important milestone in my life. I know that I was admitted on the 13th of May, 1982. Thank you. I just have a few questions for you. Easy ones at that. The SCA, as you rightly pointed out earlier, has got a complement of 25 judges. And in terms of seniority, you are number 8 on the list of judges.
Yes, now number 7 because a colleague has recently retired.
And when you were nominated by the President of the Republic of South Africa, you in actual fact leapfrogged, if I may put it that way, 7 colleagues above you in terms of seniority.
Yes.
As you would have experienced during your time as the Judge President of the Free State Division, being the first amongst equals is not always an easy job. Some even say that, it's a thankless job. The SCA has got judges committees.
Sorry, if I may just ask for clarification. I thought you were going to give me a chance to comment on the last statement about me being number 7. But now I think you are moving to something else about the committees. Do you want me to comment on that one, President?
It's up to you,
Yes, I'd like
Justice
to
Molemela,
comment.
if you
yes.
want to,
Yes,
by
I'd
all
like-
means.
Yes, thank you. This is not something unheard of in the judiciary, acting president. It has happened several times, many times. In the Constitutional Court, in the SCA itself, in the high courts, there have been many instances where the colleague who was appointed as the leader of the court was not necessarily the most senior member of that court. If I may just mention that former Chief Justice Charles Carlson became a Chief Justice without having acted in that capacity before and did an excellent job. Former DCJ Dikgang Moseneke was also appointed as a Deputy Chief Justice ahead of some senior members in that court. And I think that is the position in relation to the Chief Justice and the Deputy Chief Justice as well, in the sense that the Deputy Chief Justice has been appointed in that court without being a member of that court. So it's not unheard of, it is not frowned upon. And at the SCA itself, it has happened several times. It happened for the very first time when former President Lex Mpati was appointed. He was appointed ahead of many colleagues who were senior to him. When the current Deputy Chief Justice, President Maya, was appointed, she was appointed ahead of some colleagues that were more senior to him. When Justice Shongwe, who is now retired, was appointed to act as the acting Deputy President in that court, he was appointed in the capacity ahead of many colleagues who were far more senior to him. Respectfully, I also want to mention, acting president, that when you were appointed, you were appointed ahead of colleagues who were senior to you. So it has been happening. It has not affected the functioning of the courts. It has been embraced. And more importantly, in my instance, as I mentioned earlier in my introductory remarks, colleagues at that court had assured me of their support, and that includes senior colleagues in that court and even retired colleagues of that court who were very, very senior at the time of their retirement. So in short, I would just like to say it poses no problem. I don't see it as a challenge. When people have informed me that they are proud of the fact that I have been nominated, I don't think I have any reason to worry about the fact that I'm nominated, and if appointed, I will be appointed ahead of my senior colleagues.
So your short answer is that it is not unprecedented.
My short answer is that it is not unprecedented and that the colleagues who were appointed in those positions did an excellent job while occupying those positions.
Thank you. I'll hand over just for a few minutes to the Chief Justice. He has got something
Thank
else
you.
to
I just want to make one correction. I think most of what you said is correct. As Chief Justice, I wasn't appointed ahead of any colleague in the Constitutional Court who was senior to me. But as Deputy Chief Justice in 2017,
Yes.
yes, I was.
Yes, Chief Justice. Yes,
I
Chief
thought I
Justice.
would make the
Thank
correction.
you for that correction. I was actually referring to the point when you are appointed as Deputy Chief Justice.
Yeah.
Thank you.
Oh,
Thank
okay,
you, Chief
thank you.
Justice. Thank you.
Thank you, Chief Justice. At the SCA, we have judges' committees, 6 in total, and I see that you feature in 2 of those committees.
Yes.
And in both of them, you are not the most senior judge.
That is correct. Can I comment?
Would you,
Do you want me to comment?
do you think that that would put you at a disadvantage if you were to be appointed
Not at all.
as president?
Not at all, Acting President. The fact that a judge serves in a particular committee does not mean that if that judge is not chairing that committee, that judge has no role to play. An important role, let's say, you will recall that in the House committee, and you were present in that meeting, there's a specific matter that I placed on the agenda for discussion, and I would not want to elaborate on that at this forum, but it was embraced by the members of the committee, and a subcommittee was created, and that subcommittee was tasked with preparing a report for the committee, and I prepared a report for that committee and submitted it to the head of the House committee on a very important subject that concerns all the judges. So for me, the fact that I am not the chairperson of any of those committees is neither here nor there.
You alluded to this in the course of your introduction, but I want to pose this question from my own perspective. Are you in a position to reassure the commissioners gathered here that if appointed as a president of the SCA, you would command the respect of your colleagues at the SCA?
Yes, and my answer is without any hesitation, yes, because the colleagues have told me so.
And what would your answer be to those amongst us who think that sometimes when you articulate your views, you tend to be abrasive?
Well, no one has ever raised that with me, Deputy President. The only time when I know that most of us were emotional in a meeting was when we were discussing the problems in our court in relation to what colleagues perceived to be an unfair manner of scribing duties in terms of presiders not allocating scribing duties to certain colleagues. There, emotions ran very, very high. And I don't know whether that would be the instance that you are referring to, but I just want to inform you that if it is that specific incident, after the meeting, a number of colleagues actually came to me to congratulate me on my courage of having decided to put my views across in relation to those matters. I know that sometimes when we are being brutally honest, we might be accused of being abrasive. But serious issues were raised in those meetings, and if at all I came across as abrasive, it would just be because of the views that I was putting across, which did not find favor at that time with most of the presiders.
I would be happy if you were to clarify this for my benefit.
Yes.
During the course of your introduction, you mentioned that if appointed, you would, as a president, designate scribes for the cases that served before the SCA. Did I understand you correctly?
Yes, you understood me correctly, Acting President. Can I elaborate?
Yes, please, if you so wish.
Yes. At previous sittings of this body, this was raised, and I remember that in one instance, the former Chief Justice Mogoeng, was in that interview asking the current DCJ why it seemed to him that there were certain colleagues that were not writing judgments at the SCA. And in her response, she mentioned that it was because the allocation of scribing duties was done by presiders, and that sometimes presiders were not allocating judgments, the scribing of judgments to certain colleagues, and that she would sometimes have to intervene to ask presiders to reallocate scribing duties to colleagues. And it was at this very forum, at a different venue, that the Chief Justice made a suggestion that the scribing duties should be designated by the leader of the court. And I remember very clearly that the acting president at that time was Justice Shongwe, and he was very amenable to that suggestion by the Chief Justice. It is for that reason that I am keen to try it out as one of the ways in which scribing duties can be designated.
Thank you. Then my last question to you, in fact, it's just a proposition that I want to put to you for you to respond. Given your level of seniority at the SCA, you were far removed from the administration of the court proper. And are you able to tell the nation without any fear of contradiction that notwithstanding that shortcoming, if appointed, you'll be able to navigate that space without any difficulty.
Yes, thank you, Acting President. I am able to answer in the affirmative, simply because I have been a member of two important committees already, which is the Court Administration Committee, which I consider to be a very important committee, and the House Committee. There's another committee that's carrying out a very important function, and that's the Finance Committee. I am not a member of the Finance Committee. However, at the time when I was the Judge President of the Free State High Court, I served in the Heads of Court in a subcommittee that was formed by the Heads of Court, which is called Judicial Oversight Committee, which dealt with the finances allocated to the entire judiciary, not to one court. So I can, without any fear of contradiction, say that I have looked at the mandates of those committees. I am au fait with all of them. I have actively participated in the meetings, in the judges' meetings, in relation to issues pertaining to those committees were being discussed, and I actively participated in those discussions. In as far as one of the committees is the Library and Researcher Committee, I was at the High Court long before I was appointed as the Judge President of that court. I was appointed as the chairperson of the Library Committee. So I can confidently say that having scanned the environment, I don't see any role that I will have difficulty playing if I am appointed as the president of that court.
But the Committee on Court Administration doesn't deal with matters such as the, preparation of the roll, consecuting panels, and so forth.
Yes, indeed. However, from 2021, I was designated as a presider in a number of appeals. And the functions, only senior judges are designated to preside in matters. So I became a presider, and when I became a presider, I could not help but notice how the scribing duties can cause dissatisfaction among colleagues, because the scribing duties is done by the researchers, by the presiders, and I was one of the researchers, and at that time I was number 8 in the panel, and in the list of seniority. And the manner in which the allocation of scribing duties was done was that the head of the court would designate a scribes, and thereafter the next opportunity would be given to the next senior colleague to designate the scribes, and thereafter it's the next colleague, and so it goes until it comes to me. And when I wanted to designate scribes, I had to look who is available for scribing duties, who can I designate as a scribe for this matter. And very, very often I struggled, because I found that colleagues had already been given 2 judgments already, and yet there were colleagues who had not been allocated a single judgment. And because I was new in this role of being a presider, I discussed it with other presiders, and there are a number of them who expressed concerns about the manner in which it was done. And I do remember that at one of the judges' meeting, one colleague made a suggestion that each presider should choose only one scribe before moving on the allocations to the next to the next presider, instead of allocating 2 matters and then passing on the role for somebody else. And the suggestion was that if each presider allocated 1, 1, 1, 1, 1, when we get to 25, it goes back again to the senior presider to start allocating again. It would at least give an impression of some fairness in the allocation. But at the moment, in the manner in which it was done, I would find when I wanted to allocate that, okay, I want to allocate to so-and-so, but find that so-and-so has already been allocated 2 judgments already. And yet there are other colleagues who have nothing at all. So, I think it is a challenge that has been mentioned previously at a meeting. And I think there is a way of trying to resolve it. And one way of resolving it, like I said, is to follow the suggestion of the Chief Justice that the head of the court must designate the scribe.
Was that ever raised with the former president of the court?
Well,
To your knowledge, because I'm not aware of.
which option? The one of the head of the court designating scribes. It was raised at the interview. It was raised at the head of the court's interview.
No, that if you have 9 presiders, by the time the roll gets to the number 8 or 9, all the judges already have 2 judgments to write, and that number 8 or 9 would find it difficult who to allocate judgments to.
My recollection is that at the meeting, at the judges' meeting, where this issue was raised, the colleague who made the suggestion at that meeting is the one who made the suggestion that a better way of allocating perhaps would be for each presider to allocate just 1 and allow others to allocate, and then it goes back to the first presider. It was raised. It was even raised at the diversity training, acting president.
Thank you. I'll leave it at that. Thank you, Chief Justice.
Thank you. Okay, I'll give the minister the opportunity now, and then.
Yeah, no, thank you very much, CJ. Good afternoon, Judge Molemela.
Good afternoon, Minister.
Yeah, no, thank you. You have clarified the aspect of seniority and how in the past the court has, and in the various courts, appointments were made. My question is with regards to the various roles of leadership. How do you think will help you in these positions, the roles that you had of leading in the past?
The roles that I've played in the past will stand me in good stead because, like I mentioned, I was a partner before appointment to the bench. I was a partner in a law firm. Those are things that instill teamwork. And a court like the Supreme Court of Appeal is a court that can only thrive if there's collegiality, if there is teamwork. The reason being that we only work in panels. It's not like at the High Court where a matter is allocated to one judge. We always sit in panels. And it is for that reason that it is very, very important for there to be teamwork and collegiality. So that is something that I have been putting into effect even before appointment to the bench. And my appointment to the bench has only honed skills that I already had before appointment. And there's no time or point where I stopped employing the leadership leadership role. I have continued to play leadership roles in many other organizations. And leadership is leadership, it's standard. The principles really remain the same. The principles of leadership remain the same, and you can adapt them as you want to suit the specific needs of your organization. And that is what I have been doing throughout.
Yeah, I just checked with the list of the 7 senior judges.
Yes.
Are you able to, for the benefit of the nation, give us their, whether they are males, female, white, Indian, and so forth? If you are not, I can help.
Yes, if you give me a moment, please give me a moment, Minister.
Well, maybe if you helped him, Herr Minister, it would be quicker.
If I had, sorry.
The minister said he can help you, and I'm saying.
Oh,
maybe
yes,
if he
yes,
can
yes.
help
If
you,
you
it
can
will
help
be
me,
quicker,
Minister, that
yeah.
will.
Yeah,
Yes.
okay.
I can just mention should I mention names? Okay, the first one is the acting president of the court. He is number 1. And number 2 would be Justice Ponen, in terms now of seniority, in terms of the number of years that he has spent at the court. However, he is not the deputy at this stage. The deputy would be Justice Dambuza, black female. And one of those judges is Judge Zondi, black male. One of those judges is Judge Saljuka, Indian female. One of those judges is Justice Muchumi, black female. Justice Van der Merwe has just retired. So those are the senior judges.
So it's about 2 females that we are talking about, including you, who are senior in that court.
Yes, it's 3 females. The one colleague indicated to me that she will be retiring before the end of this year.
So it's 1.
2.
So it's only 2 females.
Yes, yes.
And we are dealing with a position where the current president of this court was a woman.
Yes, the current president was the predecessor was a woman, yes.
Yeah, and this body has always expressed interest of seeing women in leadership positions in the judiciary.
That is correct, yes.
So my next question relates to your judicial philosophy. What do you think should be the role of the judiciary in the transformation of society through jurisprudence?
Well, ours is a constitutional democracy, Minister. And so the Constitution is our Bible. And all our judgments, in all our judgments, we seek to comply with constitutional obligations. Previously, before democracy, Parliament was the sovereign. There was what is called parliamentary sovereignty, sorry. And in that context, because Parliament was considered to be the supreme body, it was always possible to employ a judicial philosophy that was in favor of human rights, even though legislation itself did not cater for that. And that is how you got judgments like, the judgment in the Harris case in 1956, where there was scope to find that there was no compliance with certain prescripts and the abolition of inclusion of colored people in the voters' roll could not succeed. There was scope to employ judicial activism there. We are now in a constitutional democracy and we are obliged to comply with the provisions of the Constitution. So
And-
the Constitution itself assists us.
Yeah, no, thank you, Judge Mulu. Last one, CJ, with your indulgence. I see you have written a number of judgments. Have you applied this philosophy that you have just articulated to us on
Yes.
this number of judgments that you have written?
Yes, I have, and I think one of them is the one that is mentioned, Tswaedi versus the state, the one on the interpretation of a section of the RGL regulation of Gatherings Act.
Yeah. Thank you, CJ.
Thank you, Minister. Judge President Workley.
Thank you, Chief Justice. I think there's no question about your judicial abilities or qualities. The issue is, and one of the things you raised in your presentation was if you are appointed to this position, you need to promote trust amongst colleagues and promote collegiality.
Yes.
And my concern is, why is there this lack of trust and lack of collegiality within the SCA? I know one of the things is that some people seem to just want to write judgments while not granting the others an opportunity to do so. And you have addressed this by saying, in your presentation, by saying that you would want to nominate the scribes, which is a wonderful way of trying to address it. Do you, from your knowledge and your working with your colleagues, do you think, is it possible to deal with those issues on that basis? And do you think that is going to reduce the tension that already exists?
I am confident that the colleagues will buy into that, because let me put it this way. There is nothing that they can complain about in the sense when the designation is done by the head of the court as opposed to by the presiders, because they don't get to choose the matters in which they are going to write judgments anyway. They are told by this presider that you are going to write in this matter and in this matter. However, some colleagues, and I really do not want us to go back, to where we used to be at the SCA. But I can assure you that there was a lot of dissatisfaction regarding that specific aspect. And that is why it was also even discussed at this forum. But the position at the moment is that there are no tensions. In the last term, there was such camaraderie in that court. There is collegiality. And I am really encouraged by the fact that the colleagues have assured me that they are going to give me support. And I have always been transparent, and I have in this body indicated that when I allocate, I will take transfer of skills into account. It's not going to prejudice any colleague.
Thank you. And I feel comfort in the fact that you are a trained conciliator and mediator. I understand when you were an attorney, in fact, you were a commissioner at the CCMA doing that sort of work. So you have that background, and I wish you all the best as far as that is concerned. The one other question I have for you.
Thank you, Justice.
One other question I have for you, and that is a bit concerning, and I need to know really about your commitment to this position, because I know that you have been previously nominated to the Constitutional Court. I also know that you were shortlisted and recommended to the President for such appointment. And my concern is that, once the positions are advertised in the Constitutional Court and people ask you if you're prepared to accept the nomination, would you then abandon this post to go to the Constitutional Court? Or would you make a commitment to be here for at least a period of time?
Thank you very much for that question, JP. I here and now want to assure the nation that if I am appointed to that position, I will retire from that position.
Thank you, Chief Justice.
CJ, if you allow me, can I make a follow-up on the same question?
Okay, all right.
So that I don't.
Yeah, okay,
yes.
do that.
Yes. You were appointed 2015
Yes,
as JP of the Free State.
that is correct.
And at that time, a lot of people were happy because you became the second woman to head a division.
Yes,
2018, you were appointed at SCA. Now,
yes,
between that period, 2021 October, you were here for the interviews of the Concord,
yes,
and you were here again in
yes.
April last year.
That's
On
right,
the
yes.
same position. Are you really certain that you want to stay there because continuity and stability is very much critical at that particular court? And this is my concern when I was looking at your CV.
Yes, I'm very confident. I've had time to think about it ever since the nomination. I've had time to think about it. And precisely, which is why I, in my introductory remarks, alluded to how the colleagues reacted to my nomination. And I did mention that it humbled me. So I have noticed how a lot of people believe in me. And I will not let those people down. And I'm saying again here and now that if I'm appointed to that position, I will stay in the position and will not make myself available for the position of the Constitutional Court.
Thank you. I hope I still have my round.
Yeah, no, I've got you here. Commissioner Moimang?
Thank you. Chief Justice Zondo. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
My question relates to one of your judgment that you have cited as your example of your contribution to the jurisprudence.
Yes,
In this regard, I'm referring to the one that deals with the Provincial Minister of Local Government of Western Cape versus the Oudtshoorn municipality.
yes,
The concern that I have, that I want you to address my concern relates to the reading in remedy. Because
Yes.
this is the question that was on the agenda. The judgment, was it not a possible encroachment by the judiciary on the terrain of the legislature? Because the judgment was that we must read into Section 34 of the Municipal Structures Act the aspect relates into the other than matter in mention in Section 160, subsection 2.
yes,
There's been you have made a reference to the judicial activism as it relates to Harry's case in the 1956.
yes,
It was
yes,
a different setup.
yes.
Now, in the current constitutional democratic dispensation, each arm of government has its own.
That's
right.
right.
I'm sorry to interrupt you, Commissioner Moimang and Justice Molemela. If you could speak up a bit, we are struggling to hear you this side, and we are very interested in your questions.
My humble, sincere apology to Chief Justice. How do you balance the discomfort that in certain instances, the judiciary goes beyond what is legislated to be its own terrain? Because reading into a remedy sometimes creates an impression that the judiciary is overreaching and therefore usurping the work of the legislative arm of government. Thank you.
Thank you, Commissioner. I think the judiciary has repeatedly, in its judgment, been very careful to assure the reader about its respect for separation of powers. I think you will note that in all the judgments where there is an allegation that the judiciary overreached or that it encroached on the separation of powers, you'll find that there's actually a reference in that judgment to separation of powers and what it entails. In other words, what I'm trying to say is that the judiciary, the courts in their judgments explain what their function entails and what they are entitled to do in terms of the powers given to the courts by the Constitution. The Constitution has given the judiciary extensive powers, including the power to test legislation or presidential action even. However, and when disputes are brought to the court, the judiciary must not be shy to deal with those disputes. And there are many judgments in which the courts refused to intervene because it respected the separation of powers. So my answer to you is that in the judgments where sometimes there's an allegation that there was separation, there was an encroachment, when I read those judgments of the Constitutional Court, I was satisfied that they carefully dealt with the matter and carefully explained why they are not actually veering into the territory of another arm of state.
Thank you, Justice Molemela. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Dodovo.
Thank you very much once more, CJ. Justice Molemela, after the president nominated you in February, I saw two headlines about your prospective appointment.
Yes.
The one was saying you are a rising star in the judiciary. And the other one was saying you are a trailblazer. Now I had the possibility to just check exactly what it means to be a trailblazer. It mentions a lot of things, and I'll not take you to all of them, but it says you are mission-driven, you are innovative. But what struck me was the fact that it also says a trailblazer is a person who is not afraid to challenge the status quo. Now, if you are appointed to this position, you'll be sitting next to the CJ, where acting President Pitts is sitting. Now, what is your view about this commission, the 23 of us? What do you think? What do you think are the defects or the limitations of this committee, of this body, as you look at it, given the fact that if you are a trailblazer, you are not afraid to challenge the status quo? What do you think about this? Because there's been a lot of talk about this body.
Well, the most recent development in as far as this body is concerned is it confirming the criteria that are going to be taken into account when processes like this one are embarked upon and how the competence of judges will be assessed. I think that was circulated in October last year, if I'm not mistaken, and I read it, and I felt reassured. And so I have nothing to complain about regarding this committee, this commission. It is a commission that has been constituted in terms of the constitution, and to the extent that there were concerns that were raised in the past about how it was conducting itself, its most recent performance is encouraging. I remember that after the first round of interviews where the Chief Justice presided as the chairperson, there was positive feedback in the media about how commissioners conducted themselves under his leadership.
Okay, the last one, CJ. Now you have a 7-point plan that you articulated
Yes.
this afternoon. And in my view, there are certain issues, whether correct or not, perceptions or misconceptions about the judiciary in general. One of those is that judges tend to use combative language. There are delayed judgments. There is no access to court. And for me, I see this as very much important to a leader of a court to look at. And you haven't mentioned them. What is your view about them?
Those are important issues, but as I mentioned in the introductory remarks, the Supreme Court of Appeal is a court that has been known for excellence in terms of its performance, the achievement of its performance targets. Even in the most recent review or annual report that was circulated, I think it was towards the end of last, it was this year, the beginning of this year, sometime was it in February. The latest statistics show that the SCA has met all its targets. It's a court that has been performing very well. And in relation to, judges being perceived as combative, I alluded to the fact that I will encourage my colleagues to observe the 10-minute rule, because I think it is one aspect that also gives the perception of judges being combative. But I think so far, insofar as speaking from my own personal experience, insofar as I have implemented it, council have been very satisfied and they've been very happy with being afforded time to really just make their submissions without any interruption from the bench.
I thank you, CJ.
Thank you very much, Commissioner Totovu. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Molemela.
Good afternoon, Commissioner.
I must say I was fortunate. I'm one of those that were part of that leadership role some 8 years ago when we were interviewed to be the JP of Free State. Mine is linked to what has been asked by Honorable Totovu, but in a different manner. Nadel noted that we have highly developed intellectual, analytical, and decision-making skills. And of course, your exceptional leadership skills. But today, when you presented the challenges of Free State, I missed the part that will maybe clarify what was raised by Nadel. They are commending you for your bravery when you confronted a judge who will not greet back and also undermine you by answering on behalf of the council. So if you can share with us so that we understand what really happened and how you dealt with that situation.
Yes, thank you, Commissioner Nambi. As I mentioned, because, there is now collegiality and friendship at our court, I am really hesitant to elaborate on what happened in the past, which has since been resolved. I think at my last interview, I was asked about it, and I remember that I mentioned that those colleagues, you know, where I had run in, specifically that one that did not greet me, and the one, all those issues have been resolved. They are now retired, and I'm still maintaining contact with them, even though they have retired. As at the time they retired, there was really peace in the valley, in the sense that the diversity training course that was held at our court in Bloemfontein really assisted us, because we were given space to have a one-on-one with each person that you have a problem with, and we had our discussions. And I did mention in the past that we even embraced. And since that diversity training, we have had a very good relationship. One of those judges, the one who did not greet me, actually, when last year he was still at the court, and when he learned that I had been shortlisted for the position at the Constitutional Court, he made it a point of coming to my chambers to come and tell me that he thinks that I will do well in that court.
Thank you. My last one, Judge Molemela. Maybe I must indicate that I was impressed by how you presented your 7 priorities, things that you'll do should you be appointed.
Thank you, Commissioner.
But linked to that, maybe what made Commissioner Dodovu to present the headline news once the president has done the recommendation to this commission, it's because of what was said by Commissioner Malema the last time we were here, if I can quote exactly what he said. Open quote, "Not mine, Judge, it's not a question, just to encourage you to continue appearing before us until things happen, because we have been trying and we don't know where things are going, but some of us are convinced. Do not be discouraged. Thank you, Judge Molemela." Close quote. That was Commissioner Malema. So thanks for acceding to that proper advice given by Commissioner Malema.
Okay,
Thanks, Commissioner.
I guess that was just a comment. You are done?
I'm done. Thanks, CJ.
Thank you very much.
No, CJ, he's locking me.
Uthanda ungathandi. Uyakufaka. I'm very happy about the pattern that I'm seeing from commissioners that side of limiting their question to 2 only, without any compulsion. Just, I like that. Okay, the next commissioner is Commissioner Makwanisha. He's on that side too.
No, thank you very much, CJ. I have 10 questions. No, thank you very much. Good afternoon, Judge Molemela.
Good afternoon, Commissioner.
No, just 2 quick questions. One, you said that you will retire at the Supreme Court of Appeal. Does that mean that even if the president can phone you again and say, I would like to appoint you, to nominate you somewhere, you won't agree?
I will inform the president about the commitment that I made here today.
Oh, okay. Thank you very much. No, I've taken note of your 7-point plan. But if stakeholders were to understand your vision for the proper functioning of the court, what would you say in 3 sentences is your vision?
Is my vision.
Yes.
My vision is to ensure that the Supreme Court of Appeal continues to perform optimally. It is the lodestar at the moment. Many courts look up to it. And on many occasions, it has been described as the seat of jurisprudential excellence. My intention is to keep things that way. However, as I have already pointed out, if the research function is not beefed up, there is a risk that that will not be achieved. And so, I am going to take steps to try and address it, and that's why I mentioned that I will also approach the South African chapter of the Association of Women Judges to see whether it cannot once again fund the hosting of interns who will assist us with this function, because it is a very, very important function.
Thank you, CJ.
I'm happy that it was not 10. The next commissioner must please forgive me if I don't pronounce his surname correctly. Professor Marumwahaye.
Thank you very much, Chief Justice. Marumo
During the
Ahai.
break, I'll try and come
Marumo
to you so I
Ahai.
can practice it. Yeah. Thank you.
Thank you very much. Good afternoon, Justice Molemela. I'm here.
Oh, hi. Good afternoon, Commissioner.
When I came here, I was interested in two judgments that you penned. The Harialel judgment that dealt with the costs for legal costs in respect of students who are litigating.
Yes,
And the Harvey judgment that dealt with testamentary trust.
yes.
But when you presented your 7-point plan, it took me away from the judgment. And I want to ask you something quite operational in relation to the SCA. Now, I want to take you to the rules of the SCA, the rules for special leave to appeal, Rule
Yes.
6. When you look at those rules, in the definition of the rules, court day is defined,
Yes,
which is a day that excludes weekends and public holiday.
yes,
But when you look at that rule, it says you need to do that application within a month.
yes,
And the response or a responding affidavit to the application must also be done within a month.
yes,
And then the reply should be done in 10 days.
yes.
Now, herein is the challenge. Now, I just want to hear your view on it, if you have thought about it. How is this month computed? In other words, if you're having a person who receives a judgment from the High Court on the 12th of December, for instance, and we know we are going to the close of term,
Yes,
and then we are going to come back on the 16th or 15th of January,
yes,
and then you have to bring this special leave to appeal within 30 days.
yes.
How do we compute this 30 days? Is this rule consistent with the rules of other courts, for instance, where we know that if you have to do things within a particular day, because a month is not defined in the
Yes.
terms? What is your view? Because I think in practice, this has caused a real grade of uncertainty as to how do we bring these particular, and the thing is the secretary, the registrars in your court are very strict with this thing, because if you get a judgment on the 8th of this month, then you have to bring the application before the 8th of next month.
Yes.
So how should we understand this rule?
Yes, I dealt with a matter like that very recently, where there was a debate as to whether there should have been an application for condonation or not. However, my colleague and I, the panel that attended to the appeal, our conclusion was that it was not necessary. So we did not require the applicant in that matter to submit an application for condonation. And we considered the application for the petition, we considered it without, none of us had any problem in concluding that it was not necessary for condonation to be applied for. I think it's just really a question of the interests of justice. We all know, as you correctly pointed out, that the periods that are specified in the rules means that the calculation should be court days. And I don't see why it should not be court days. So I don't know, I haven't, honestly, I'm not aware that it has been a problem in the past in relation to other panels, but it has never been a problem in relation to the matters that I dealt with. You do find quite a lot situations where the applicant, perhaps, for the abundance of caution, the applicant actually applies for condonation. And so there's really not a problem of having to say, is it late or is it not late? Because there's an application for condonation that is not even opposed.
I guess my question is, should the rules, I'm not sure, as the head of court, I'm not saying that you are the one who amends and who, but that's a process that you can initiate, right?
Yes.
Should, or are you not going to think deeply about this and say, perhaps maybe we need to get these rules amended so that we have consistency?
Yes.
So we know if it is 30 days, it's 30 days, because days are actually defined in the rules, so that we don't have this 1 month, which is not defined, which nobody knows actually it is.
Yes.
And then it depends on the panel. I mean, you don't choose your judges. You might get judges who are saying, no, 30 days.
Yes, we have a rules committee, as I mentioned before. There are various committees, and there's a rules committee, and the mandate of the rules committee is to bring issues like those to the attention of the relevant authorities. Where there is a need for a rule to be amended, they flag it out, we discuss it at the judges' meeting, and action is taken. So as I said to you, I wasn't aware that it had been an issue. It's a matter that I will, whether I'm appointed or not, it's a matter that I will make follow-ups on.
Thank you. My last question. I always find it quite difficult to understand, and this is not your problem. I'm just asking you because you are the incoming head of that court. Gauteng currently, it's far ahead of the whole country. We don't litigate here with originals.
Yes.
We upload things in Gauteng.
Yes.
Right? And we use case line.
Yes.
And we are just waiting for everyone to join in.
Yes.
But the Constitutional Code, even though it doesn't have a case line system, it has migrated to the electronic form. In other words, you are able to launch through email and you are going to be assisted.
Yes.
But in Bloemfontein, you still need to get your correspondence. You still need to make sure that you send issues and they receive documents, and you can actually, they can file copies. Then after 10 days, you need to bring originals to the court. And I'm saying this based on your point 4 of your, which is court modernization.
Yes.
What is your plan in relation to making litigation easy? Because this insistence of the past of originals and all these kind of things, to some extent, they have a negative impact in delivering access to justice speedily, as one would expect.
Yes, we are already using case lines in relation to our appeals. The problem at our court in terms of technology is that we have a very unstable network. Internet connectivity is a serious problem, and those are issues that we have raised with the Office of the Chief Justice. And at a very recent meeting at our court, they indicated that they are going to increase the bandwidth, which will, enable us to operate more efficiently. But we do embrace technology, and because of COVID-19, a lot of improvements were made. Remember, there was a stage when we were doing virtual hearings, and there was a stage when we our court was doing virtual taxations, which I'm told, it was a resounding success doing them virtually. The only letdown for us is the stability of the network. And once the bandwidth has been increased, I don't think we'll have any problem embracing everything that has been mentioned. In fact, my proposal, which I didn't mention because then I ran out of time and I was rushing out of it, was to say we should resume virtual taxations because then they keep everybody, the support staff, everybody in a state of readiness for the full rollout of e-filing.
Thank you very much, Chief Justice.
Thank you, Professor Marumohai. Then I'll go to Commissioner Matolo Lepu, but before I go to her, I just want to say in relation to the Constitutional Court, we would have adopted the case lines by now. It's just that there are certain issues of illegality that you have all seen in the media that are holding us back, but we want them yesterday. Thank you. Commissioner Matolo Lepu.
Thank you, Chief Justice. Good morning, Justice Molemela. Good afternoon, sorry. One of the things I wanted to tease you on is, you have mentioned the celebration of our celebration, which I'm really happy about, that we are celebrating the 100 years. And knowing you to be a very passionate trainer and mentor, if you are appointed, are you able, because if you are appointed and we are not continuing, we'll be running short of other mentors, will you be able to proceed, continue with mentoring young female judges, young practitioners as you have already, and training them on trial advocacy?
Yes, absolutely. I will continue doing that. It is my passion. And sorry, I didn't greet you back, Commissioner. No, it is definitely.
I'm sorry, Commissioner Matolo Lepu, if you could speak up a little bit. We were struggling this side to hear you. I'm sorry to take you back to your question.
Chief Justice, must I repeat my question?
Yes, please.
Okay, I just wanted to say, at least she mentioned the 100 years celebration,
Yes.
which I really, we are all excited and think it will continue. I just wanted to find out from her, knowing her, she's been a trainer on trial advocacy and she's very passionate about it. And if she gets appointed to this position, will she still continue to be a trainer on trial advocacy for young practitioners and young female judges?
Thank you, Commissioner. Yes, definitely. If invited, I will make myself available as far as possible. Mentoring is something that I really embrace. It's my passion. I like to impart knowledge where I can. I like to hold the hands of my female colleagues that are new on the bench. I'm still doing, I did it at the High Court. There are at the moment 8 judges who are permanent judges of that court in the High Court. And that makes now 50% of the complement in that court. I had a hand in the acting appointment of every single one of them, every single one of those 8 judges. I was looking at my documents and realized that in the 3 years that I was the judge president, I was responsible for the acting appointment of 22 female judges. I will continue with my commitment in relation to the empowerment of female judges. And I am concerned that even though we have achieved parity in a number of our courts, it has still not been achieved in the profession as a whole. There was an article that was published in De Rebus sometime last year, and I remember this because I alluded to this at the annual conference of the South African chapter of women judges, that sadly there isn't that parity in the organized profession, and it is a concern because legal practitioners, attorneys and advocates, that's the pool from which judges are appointed. And so we need to strengthen it. So I know that doing training as part of trial advocacy goes a long way in terms of making practitioners feel confident to participate in complex cases and in that way make them ready for appointment to the courts.
Thank you, Chief Justice. My second question is just a comment. The BLA always laments on the problem of allocation of cases at the SCA. And is a perception out there to say that black judges are being marginalized in being given intellectually challenging matters. How are you going to deal with that, or is it still the case?
No, it's not the case. And I think when I was going through my priorities, I did mention that I will continue to do what my predecessor was doing, because that is one aspect that she made sure that it was attended to. There was a fair spread of complex work to other colleagues. I have participated in a maritime matter where she was the presider, and at that time I knew very little about maritime law. So, and I know, I have seen from the role that she kept her word in terms of spreading, transfer of skills in relation to certain specialized branches of the law. And I will continue to do that as well. And I think I did mention it when I was speaking about allocation.
Thank you, Chief Justice.
Thank you very much. I think this side too is doing its bit. Commissioner Lucas.
Thank you, CJ. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
I've been listening to you, and I also really want to commend you on your approach in the past in the High Court, particularly with regards to making sure that you have a proper and a people-centered approach, particularly since we do have the problem of people saying that in many instances justice is not accessible. And you have actually, in your input, showed that you have really struggled to make sure that it became accessible for those that are not so, or the marginalized, let me say the marginalized people.
Yes, thank you. Thank you, Commissioner.
Now, I was listening, but I was really trying to hear you on that one. When you spoke about something that was about a female lawyer, and then you said that, in fact, this law society as well as the court have actually institutionalized inequality or something like that. That is what you exactly said. I was just wondering, in your view, what is the remedy? And what have you been contributing to make sure that you address that specific anomaly that we see, since we are struggling to make sure that women really take their rightful places?
Yes, thank you, Commissioner. I was actually, the Wookie case is a 1912 case that was heard in the Western Cape High Court in 1912. And so I was just giving a historical background to why there is now a celebration of this act that was passed in 1923, because that act actually is the one that came to the rescue of women in the sense of saying, women, stating the obvious really, to say women are also persons and they shall be allowed to enter the legal profession. However, by then, a period of 10 years had gone by. And obviously in that 10 years, many women had already been blocked from even trying to enter the profession, not let alone, progress through the ranks. Just entry into the profession was blocked. But that was in 1912. I don't know whether I've answered your question,
No.
Commissioner.
No, I just wanted to have that background and thank you. But now, 100 years later,
Yes,
what is the situation? And
Yes.
what do you think we can do more to
Yes.
improve on that specific situation?
yes,
Thank you.
100 years later, the situation has improved a lot. And we have to acknowledge the strides that have been made. I mean, today we have a female Deputy Chief Justice. It's a huge achievement. And there's gender.
And also in 85 years.
Excuse me?
In 85 years.
Yeah, well, they say better late than never. So it has happened and we are happy about it. But the whole aim of the 100 more campaign celebrations is to also, ensure that it remains on our radar to make sure that women are allowed to progress in the law profession, in the legal profession in particular. So we celebrate the strides that have been made, but we identify areas of weaknesses and we are saying what should be done about these areas of weaknesses. And the one that I've already alluded to is that unfortunately, parity in the legal profession has not yet been, gender parity has not yet been attained. And that's what we are pushing for. And I'm happy that we are now having this 100 more campaign because I think it will accelerate the speed of transformation, gender transformation.
My last question will be, I just read today or last night that one of your colleagues was saying it seems as if South Africa is becoming generally a lawless community. What is your view on that?
It's the first time I hear about that, Commissioner. I don't know the context in which it was made. Was it in a judgment?
Sorry, CJ, if I'm just asking yourself, what is your view? And I read that, and sometimes when things like Tabo Bester happen and things.
I'm sorry, Commissioner Lucas, to do this to you. I had not heard what the question was, but now that you are going to repeat, I would really want to make sure I hear. Will you just?
No, what I was saying to her,
speak up,
generally, I read something of one of the colleagues in the judiciary that say South Africa seems to become a lawless community.
Oh,
So I was
okay.
just asking, what is her view?
Okay.
How does she see it? Not
Okay. No,
specifically
I
to
understand.
comment on what the person said, but her own view.
No, I understand.
Yes, I suspect, I don't know the facts, but I suspect it was probably said in the context of giving a judgment that relates to crime. It's an aspect that has been bemoaned over and over and over again, in our judgments. The fact that we have high crime rates and so forth. So I think it must have been said in that context. And I really can't comment on whether it was a fair comment in the context of that matter or not. But I can just say in many, many judgments, especially judgments relating to gender-based violence, which is very prevalent, regrettably, in this country, we have bemoaned the fact that the prevalence is really shocking and unacceptable, and that it gives an indication that we are now slowly turning towards a lawless country.
Just finally, I hope if you are being appointed, making the Supreme Court of Appeal more accessible will actually assist in addressing what we have been experiencing so far. I just make it as an observation because remember, I have two questions.
Thank you, Commissioner.
Thank you very much, Commissioner Lucas. I have a certain number on my list, and I would like to stop with that list unless somebody feels extremely strongly that they want. And in the commissioners I have on my list, Commissioner Mahube, Commissioner Chaba, Commissioner Baloi, Commissioner Steinberg, Commissioner Pillay. If
I did raise my hand, Chief Justice.
you feel strongly.
I did raise my hand.
Oh,
I just
okay.
want to reserve my position if I'm covered by.
If you are
my
covered,
colleagues, yes,
okay,
then I
no,
won't
that's
ask.
fine. Okay, all right. Okay, I think everybody seems to be fine with that. Oh, I'm sorry. I don't know what's wrong with me today, commissioners who are attending virtually, but I think my excuse is that I've got the candidate on the screen and you are not appearing when she's there. Somebody wishes to ask a question there. I'm going to come back to you after Commissioner Mahube. Commissioner?
Thank you very much, Chief Justice. Good afternoon,
Good afternoon,
Justice
Commissioner.
Molemela. Justice Molemela, there's one thing which you mentioned, which I would like you to unpack just very briefly, where you said, when you were outlining your 7 priorities, that amongst others, you would want to give space to lawyers and yeah, to make, because currently there is a perception that
Give council 10 minutes and sometimes it's called, I think it is beneficial. And other presiders, some of the presiders also applied, and I think it has been beneficial even in those matters where I was not presiding, but it was implemented. So I am saying that in line with that resolution that we have taken, I'm going, if I'm appointed, I will make it a point that I encourage my colleagues to religiously observe it. I do that. Most of the advocates indicate that they will welcome it. There are a few who have waived it and said they don't need it, and that works out fine. And how this 10 minutes indemnity came about was just in terms of adopting best practices from the Constitutional Court, because that is what is done at the Constitutional Court. Council advocates are given 10 minutes within which to make their submissions without any interruption. And even in the Constitutional Court too, I know that sometimes advocates indicate that they won't, you know,
I forgot to mention that it might come back, but the interruption is about 5 minutes or so, and then we are back. So maybe let's wait. Yeah.
okay. You done, Justice Molemela?
yes, I was just explaining that it's a best practice that we adopted.
Hang on.
Oh,
Those attending virtually might not be hearing,
Oh,
I'm not
okay.
sure. Yeah, so I think let's wait. Yeah. Oh, they can hear. You can hear, commissioners? Yes. Okay, all right. Then we can continue, yes.
Thank you very much. Thank you, Justice Molemela. Then there is another matter which you raised with regards to diversity training and the need amongst the members of the judiciary. At what scale would you put that out of 10, the need?
I beg your pardon?
In a scale of 10,
Yes.
where would you put the need for this diversity training amongst members of the judiciary?
Well, as I said in my presentation, it will just be a follow-up. Follow-up in the sense that we have already had diversity training twice. And on the last occasion, the facilitator indicated that it would be a good idea for the last part of it to be finalized at the court itself. And we did not get to that one. So I'm just interested in that aspect as well.
Thank you, Justice Molemela. My last is, in your CV, I see that you've been doing it, when you were acting in the Constitutional Court, you did additional work.
Yes,
Amongst others, you had a visit, for instance, to the Zonderwater Correctional Center.
yes,
And then it goes on, the report goes on to say that actually you were able to present that report even before your time had lapsed at the Constitutional Court.
yes.
I would be interested, just very briefly, just to get an understanding of what exactly you were investigating or you were following up on. It's a correctional facility and,
Yes.
and everything right now, topical issues are about
Yes.
our correctional facilities. What exactly were you dealing with there?
Yes, as judges, we routinely do prison visits. And when I was at the Constitutional Court, it was at the time when Justice Cameron was also still on the bench. And he was encouraging colleagues to do more frequent prison visits. So I decided at that stage that I would conduct a prison visit. But it was not intended for a specific purpose. It's something that we do routinely to check on the conditions of the inmates in those facilities. And so what happens is that we do an inspection in the company of the prison warders. We go around the entire facility to check the conditions, whether they are ideal or not. And I do remember that in one of his, while he was still a judge before his retirement, Justice Cameron did a prison visit in a prison or correctional facility somewhere in the Western Cape and discovered that there were actually lice in the cells. In the prison, whatever prisons that he visited, he discovered that there was overcrowding. And the fact that there was overcrowding was also dealt with at the level of the Provincial Efficiency Enhancement Committee meetings, where the regional commissioner was also one of the stakeholders represented at that forum. And I remember that in her reports, she would actually mention that the level of overcrowding in so in all instances, I filed a report. Even the report on the Zonderwater prison, I think it's available on the internet.
Thank you very much.
Thank you,
Justice Molemela.
Commissioner.
Thank you, Sir.
Thank you, Commissioner. Commissioner Klaba.
Thank you
Anyone
very
who is
much.
covered, that's
Yes.
most welcome.
Thank you very much, Chief Justice. Good afternoon, Justice.
Good afternoon,
Molemela.
Commissioner.
Thank you. Your nomination for this position has received wide support within the legal fraternity. Some even say you are an independent thinker who is never shy to write dissenting judgments. How many of those how many dissenting judgments are under your name, if I may know?
I don't know, Commissioner, that's my honest answer. And I deliberately refrain from taking stock of the amount of dissenting judgments that I write, because I have deliberately not listed here because I accept that I was wrong because, I was overruled. So that, it's par for the course. If you have been overruled, you have been overruled and you accept it. But if you, of course, feel strongly about your view, you write a dissenting judgment and put it out there. So I am sorry, I don't recall how many.
Okay. But has any of those dissenting judgments?
Only one judgment where you have been overruled, which would be a very good record, because you have been a judge for about, 15 years, more or less?
Yes.
If you have only one judgment that has been overruled, that would be a very good record. I thought
Yes.
that's what I picked up. Is that consistent with your recollection?
Yes, I think it's 3 judgments, if I'm not
Oh.
mistaken. Yes.
That is still a very good record.
Thank you,
after
Chief
15
Justice.
years. Yeah.
Thank you.
Okay, Commissioner Baloyi?
Thank you, CJ. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
In the interview in April, Commissioner Schlemmer discussed with you there was a discussion about the appeal jurisdiction of the Constitutional Court having been widened, and that now you see more and more cases from the
Yes.
SCA and what that possibly means about the judgments that are coming out
Oh,
of the
yes,
SCA.
yes.
Yes, but I'm not raising that with you.
Okay.
What I'm raising with you, and your answer to that was you alluded to the concerns that had been expressed in the consultation process.
Yes.
About expanding the
That's
appeal
right.
jurisdiction of the CC.
Yes.
And then you also said, of course, it's in the nature of human beings. When they have another leg to go to, another court to go to, they will inevitably do that.
Yes.
Brings me to my question. You have a statutory creature of a reconsideration application when leave to appeal has been refused in the SCA by a panel of 2 judges.
Yes.
Then you have a reconsideration by the president,
Yes.
which if you are appointed, you would be that party or that judge that reconsiders these
Yes.
applications. Now, it seems that because it's human nature and that extra leg of having another bite is there, that almost automatically people apply for reconsideration. There seems to be a lot of that.
Yes.
Now, my question is, in your experience, have you found that this further step serves any real and meaningful purpose in adjudication, finality of matters? And more specifically, are there really significant cases where the president has granted leave where it had been refused?
Yes.
And if it doesn't serve any real purpose and serves only to delay the further finalization of the matter, should that not be one of your priorities to seek a legislative amendment? Because on the outside, it looks like it serves no real meaningful purpose other than to delay finality of matters. And I would have expected that it would be among your priorities to seek legislative changes.
Yes, thank you, Commissioner. In the interview of DCJ Maya, I don't remember, I think it was in the interview for the DCJ position. It was traversed with her, that specific aspect. And she gave a response, and I remember the minister said that there were already steps underway that had already been started to come up with an amendment. So I did not deal with it because of that information that steps are being taken to effect an amendment. I have personally, in the last term, I did one of those applications. We call them 17-2F because it's in terms of that provision of the Superior Courts Act, and I granted leave. There are instances where the application was referred for oral argument. And in that process, which is now a hearing of 5 judges, there are instances where it was successful, actually. There have been instances where it was also unsuccessful. The one instance where I remember it was successful was in a situation where there was a case from the High Court where there were multiple accused persons. And one accused person applied for leave to appeal and it was dismissed. And that was the end of the matter. And subsequent to that, the erstwhile co-accused applied for leave to appeal and it was granted. And when the one who had applied before, the accused, in respect of which the application was dismissed, when he heard that his former co-accused had been granted leave, he brought an application for reconsideration. And it was referred for oral argument, and I was in that panel, and in that panel we granted leave and upheld the appeal and reduced the sentence, having taken into consideration that in the other matter where the co-accused was successful, he had also been successful on appeal in the sense that the sentence was also reduced. So that was a consideration for us to say, these are similar cases and one would expect the outcome to also be similar. And having taken all the circumstances into account, we reduced the sentence.
Does it mean that notwithstanding the expanded appeal jurisdiction of the Constitutional Court, your view as a candidate for this position is that the reconsideration process or application should be retained? Is that what you would advocate for? Because you think it serves a real purpose, notwithstanding?
I think when that provision was included in the Superior Courts Act, it was specifically to address a situation like that. Unfortunately, and the former president of the court also mentioned in her interview that unfortunately now everybody whose application for leave to appeal has been dismissed is now bringing an application for reconsideration. So I don't have a short answer for you. I'm just saying there are circumstances where that 17(2)F application benefited an accused person. And perhaps one could argue that, well, even if that accused person or that applicant in the application for leave to appeal had approached the Constitutional Court too would in any event have granted leave to appeal and perhaps, also upheld the appeal later on. So that's my answer to it.
Thank you, CJ.
Thank you. I just
Follow-up,
want
CJ?
to mention to the commissioners on the virtual platform, I have not forgotten you. I've added you on the list of the remaining commissioners who will be given opportunities. Commissioner Steinberg.
Thank you, Chief Justice. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
We've heard a lot about your considerable administrative prowess this afternoon, which is a crucial component of the judge, but not much about your intellectual vision for the court. I'm going to ask
Commissioner Steinberg, I wonder whether, we can't hear.
I'm
Maybe
sorry.
it's because you're facing
Sorry
more
about
that side, yes.
I said that we've heard a lot about Justice Molemela's considerable administrative prowess, which is a very important role she's going to play in this court. But we've heard little about her intellectual vision for the court, and that's what I want to probe. So a general question as to how you see your intellectual vision for the court should you be leading it. 2 specific questions, whether you answer yes or no, still to answer the first general question.
Yes.
There is a perception that the SCA's strength in a couple of areas has diminished over the years, one of them being commercial law, where increasingly one sees parties choose private arbitration because of a perceived weakness in all our courts on commercial law. And in the SCA in particular on constitutional jurisprudence. So I wonder if you could comment on those two perceptions and share with us your vision for the court, your intellectual vision for the court. Thank
Yes.
you.
Thank you, Commissioner. In one of the priorities that I alluded to, I mentioned that I would optimize acting appointments. And because now in the end, I was rushing through everything because of time constraints, I did not come to that specific aspect of training to say, and I remember I mentioned that I am alive to the fact that because of attrition, we have lost a number of colleagues, and obviously if they leave the courts because they are now, is the fact that judges undergo training very frequently. There is training that is provided by the South African Judicial Education Institute, which is referred to as SAJE. And it is training that is provided to all the judges, including the judges of the Supreme Court of Appeal. And this SAJE has already provided training to SCA judges on maritime law. I attended the training. It has provided training on taxation. I have attended its training. It has provided training on intellectual property. I participated in that training, and we will continue to participate. And many judges at the SCA have been participating in that kind of training. And in addition to that, and that's where one could involve the judges that have recently retired in terms of further transfer of skills, would be to also engage them in training. The SCA has been doing that for a number of years. In addition to the training that is provided by SAJE, the judges of that court have been providing training to other judges. Justice Willis gave training on maritime law at the Supreme Court of Appeal. Justice Harmse gave training on intellectual property. Justice Navza gave training on judgment writing. Justice Brandt gave training on judgment writing. And the colleagues have benefited from those kinds of training. And so it's very rare where you find a colleague who has not dealt with a single, I hear you talking about commercial matters. Those are matters that we deal with routinely. And one thing that I discovered already in 2008, when I was appointed at the High Court, was that there were a number of companies that inserted arbitration clauses in their contracts routinely. And I know also that sometimes it is the parties who don't have an arbitration clause who agree out of court that the matter should be referred for arbitration. It is the choice of the parties. It is not because there's a diminishing expertise from the SCA. Remember, they were doing this already in 2008, while there was a lot of expertise at the SCA, at least in terms of people acknowledging that there was expertise. But even then, already, parties were taking their matters to arbitration. We can't help it. But I sit here in this forum to say that our judges are ready to deliver. We have received training. We will continue to be receptive to training. I alluded to the fact that the SCA has been referred to as a place of jurisprudential excellence, we'll continue to do that. I think the fact that many of the judgments of the Supreme Court of Appeal have been, the appeal in respect of those judgments was dismissed by the Constitutional Court also attests to the fact that there is in fact expertise at the Supreme Court of Appeal. Otherwise, they would uphold the appeal. So I think insofar as somebody may say now people are taking their cases for arbitration because there's no expertise at the SCA, that would be, to say there's no expertise would be a fallacy.
Thank you. Just to follow up on the first part of my question.
Yes.
Maybe just to be more specific.
Yes.
There's always a tension between the doctrine of precedent on the one hand.
Yes.
And the injunction in section 39(2) of the Constitution on the
That's
other
right.
hand.
Yes.
To develop a progressive,
common law, yes.
transformative jurisprudence.
Right.
How do you reconcile those two sometimes competing imperatives?
I have had no difficulty implementing the provisions of section 39(2). In terms of developing the common law, it happens all the time, really. And I haven't really noted any tension. I know that in relation to many commercial matters relating to contract, where the sanctity of contracts was in issue, we have dealt with those matters, and in some cases, Ubuntu was infused. And I mean, this is something that has been sanctioned by the Constitutional Court. And in other instances, it was not infused. I recently had a matter where, on the basis of the doctrine of precedent, relying on the judgment of the Constitutional Court, we couldn't interfere, and we preserved the sanctity of contracts in those matters. So it really depends on the merits of each case.
Thank you. Thank you, Chief Justice.
I must thank you, Commissioner Steinberg, particularly for raising an area that might not have been raised before, because it's quite an important area, namely on the intellectual side, the contribution and so on, because when you are in a leadership position, you have got to lead even in that area as well. You are expected to lead. Thank you. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
I do have a question for you around one of your 7 areas of priority.
Yes.
But before I do that, it would be remiss of me not to touch on the question around abrasiveness.
Around the, sorry?
Around you being abrasive. And it's really just a comment.
Yes.
That you are not the first outspoken woman in a professional space, and definitely not in the legal space, to be accused of being abrasive, and I'm sure you won't be the last either.
Yeah.
Can I then go to the 7 areas of priority? You mentioned one of them being, that was number 5 on your list, the optimization of acting appointments.
Yes.
And you also told us how you have, in your position as JP at the Free State High Court,
Yes.
how you were able to use the notion of acting appointments to further the transformation agenda. I think you mentioned that there were over 20 women
Yes.
that were attracted into the space
Yes.
through being offered acting appointments.
Yes.
Now, through the interview process in this forum, we've come across a number of candidates who lament the fact that they don't have access to or haven't been invited to act in the SCA. And you'll know also that regrettably reflects badly on the applications for appointment to the SCA. It's one of the factors we take into account. Given that it's one of your areas of priority, what changes do you see yourself making just on that question on being, on a more kind of equitable distribution of opportunities to act?
Yes. Thank you. That is something that I would, well, let me start by saying at our court, I indicated that already we have more female judges than male judges, so there is no problem there. A proposal that I would make at the heads of court meeting would be for every division to have an acting judges committee. You have heard that, you know, all the courts, most of the courts operate through committees. The SCA does that, the Free State High Court does that, the Constitutional Court does that. In fact, when I introduced it at the Constitutional Court, it's something, it was a when I introduced it, sorry, at the Free State High Court, it was a best practice from the Constitutional Court. So my suggestion would be every division should have an acting judges committee that would assist the JP in terms of identifying candidates that could be appointed to come and act. And of course, gender parity would be a big consideration in all of that, coupled of course with competence. So I think if, quite apart from the head of the court, there is a committee that makes recommendations to that head of the court, I think it will work.
And can I just, my question was more focused on acting appointments in the SCA.
Yes.
And just to kind of use layperson's language, you'll find that judges with social capital are able to access those acting appointments while others aren't. So I was interested in what kind of mechanisms you would introduce to make those opportunities more easily accessible for all judges, not only for those who are known to the president of the SCA.
Thanks for the question, Commissioner, but I beg to respectfully disagree with the suggestion that only the candidates that are known, that were known to the president of that court were being appointed to that court. And maybe I can just mention this, that when she made a decision to invite me for an acting appointment at that court, we did not know each other. She and I met at a hair salon and discovered that both of us were judges, and it was at that stage when we introduced ourselves. And when I introduced myself, she said, "I've heard good things about you, send me your CV." And so, I mean, she did not know me at all. And later on, I think at that time when she asked me for a CV, it was when Justice Mpati was still the leader of that court. She was not the president of that court as yet. And maybe a year later or so, then she contacted me and said, "Well, now that I have the opportunity to invite you, I'm inviting you." And she had requested me to send my CV, and she had requested me to send my judgments. So it was on the basis of the judgments that I had presented. And of course, she had mentioned that she had heard good things about me. And so it was on the basis of that, not on the basis of the fact that she knew me from somewhere. So I would respectfully say, I don't think that, that was the basis upon which colleagues that were invited to that court were invited. But then I would also want to give you the reassurance that when I invite acting judges, I will. The other consideration when any court invites acting judges is on the basis of the judgments that serve before us in our appeal. So sometimes you find that there is this very good judgment that has been written by a colleague at the High Court, and maybe this colleague has written several judgments of that nature, good judgments, and we just bring it to the attention of the president. So what I would do would be to invite colleagues to make recommendations in relation to those kinds of colleagues. And of course, I will request their judgments to be able to make an assessment. Because as Justice Mpati mentioned many years ago, the SCA really needs to get the best of the best.
Justice Molemela, I think you probably misunderstood what I had put to you about the previous process of selecting acting appointments. There was
Yes.
no suggestion of impropriety
Oh,
in
okay.
relation to the previous president. I was more interested in understanding your...
I'm sorry for having misunderstood your question.
Sure.
Yes.
I'm more interested in probing your systemic response. I'm
Yes.
trying to understand when you listed as an area of priority.
Yes.
What system are you going to put into place? And that's what I was trying to probe. I'm assuming that once you've listed it as an area of priority, I know you ran out of time, so you were not able to develop it.
Yes.
And really what I wanted to do, because like you, I'm a firm believer that it is an important tool for transformation.
Yes.
I wanted to give you the opportunity to develop it and
Yes.
to tell us what system you see yourself implementing,
Yes.
which will make it a meaningful tool in the SCA.
Yes. Thank you. As I have mentioned, it's something that I will raise at the heads of court to suggest that every division must have an acting judges committee. The SCA already has a committee that is called the induction committee, and it's the committee that inducts all the acting judges in that court. I would consider adding in the mandate of that committee, making recommendations in relation to acting appointments. I have already alluded to the fact that on many occasions when we deal with our appeals and we see well-reasoned judgments, we just bring it to the attention of the head of the court. Perhaps what we could do, and I think what we should do, is that to have a standing arrangement where colleagues, as and when they note these things, they bring them to the attention of the induction committee. The induction committee now will have an additional mandate in terms of the appointment of acting judges. And then that committee can then source the judgments of these specific candidates and then bring them to the attention of the head of the court. So I think you will agree with me that that will be a fair way of assessing whether somebody is in a position to come and act or not. So we will take, in other words, we will take competence into account, but I think I did mention that on my radar screen will also be the diversity aspect. And I don't have any worries about that aspect because I know for a fact that there are many competent judges, female judges at the high courts. I hope I've answered the question.
Thank you, Justice Molemela. Thank you, Chief Justice.
Thank you, Commissioner Pillay. Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon, Justice Molemela.
Good afternoon, Commissioner.
I'm one of those I'm very pleased that I was part of your journey from 2014 when I was in the interview, my first JSC sitting in October 2014, when you were interviewed for JP of Free State. And I think at that time, you were noticed, like Commissioner Malema said, you were noticed for being fiery, and I used the word fiery and being somebody with potential. And I'm very glad and want to congratulate you on your nomination by the President.
Thank you. Thank you, Commissioner.
One of the things that you bemoaned, and I think it speaks to the optimum efficiency of the Supreme Court appeal, is the lack of researchers, and I think we heard this earlier on in the day during our meeting. And I think that came out quite strongly. And the second issue was the lack of law reports and books.
Yes.
Now, in 2022, I recall the minister, our current minister, Commissioner, saying that, well, he didn't like the idea of private funding or donor funding.
Yes.
When it was raised by the NPA. But subsequently, there's been a change of heart, new policies in place now where in 2023, I think about 30 million rand has been given kind
Yes,
for its function.
yes.
Now, do you not think that the similar kind of system with checks and balances and without compromising the independence of the judiciary can be used? Because surely you can approach universities and other institutions to second interns. You could approach the law society. You could approach, the book publishers to provide books through the SCA so that we can make it more efficient. I just want to know what's your opinion in that regard.
Yes, yes. Thanks for the question, Commissioner. The stumbling block for the judiciary is Section 10 of the Superior Courts Act, because it expressly states that the administration of the funding in relation to the administration of the courts must come through Parliament only. So it would be difficult to source donations from elsewhere. But like I said, Commissioner, interns were engaged at the SCA a few years ago until the South African chapter of the International Association of Women Judges ran out of funds to further finance it, because the researchers had to be paid and accommodation had to be paid for them. And in my presentation, I specifically mentioned that the local university has the Faculty of Law. So I will, when approaching the IAWJ again, I'll bring this to their attention, that perhaps if they are unable to provide more funding, consideration could be paid to engaging interns that are based in Bloemfontein, so that there is no additional cost in relation to their accommodation, because previously their accommodation was also being paid for. But in addition to that, another alternative, of course, is for them to do the research function remotely. We were doing virtual hearings of our appeals. It was a successful exercise. I think they too can be able to do the research function remotely, because in any event, even in relation to the researchers that are part of our staff complement, in most instances, we communicate with them via email. The judgments are sent to them via email. They are sent back to us via email.
Thank you very much. I think we're playing a game of tennis. You've put the ball back in our court as members of parliament, because it will require amendment to legislation. But I think, Minister, it's something you must take serious note of. My second question and final question relates to the public opinion on the judiciary. Now, it would seem in recent time there is a waning of public confidence in the judiciary.
Yes.
And I remember Commissioner Commissioner Zepu last year asking you about your involvement in a certain organization that was involved in land reform, etc. And
Yes,
you decided to withdraw. You decided to withdraw because of a possible conflict of interest. But earlier on, when you were presenting yourself, you spoke about the involvement of judges in public discourses, and I think you mentioned the radio as an idea.
Yes.
Now, is there any other way you think from the side of the SCA or from the side of the judiciary generally that one can instill this kind of confidence, public confidence in the judiciary? Are there any other ideas that you may have that you want to share? Thank you.
Yes, thank you, Commissioner. I added those two about a structured way of doing it, that we do it in panels, we visit schools, we participate in radio interviews, and those radio interviews could be, translated into all official languages, so that the reach can be as wide as possible. There are many things that can be done. The one thing that I know a number of judges have been doing is giving public lectures at universities and participating in panel discussions at those platforms as well. I know I have done it a couple of times at the University of the Free State. And I think that's what colleagues will be willing to do, because I don't think it creates, it might just be a perception, but I don't think it creates a good impression if, you know, the society's view about the judges is that they are disengaged when it comes to matters of the Constitution, because we are not. Hence my suggestion about having a structured arrangement in terms of which we can formally participate. I did attend the conference on the Constitution a few weeks ago, and I was there with a few colleagues, and yes, we did hear a few people saying that judges are disengaged. And I think our response would be to dispel that notion, because we are not uncaring. And I think our judgments show that we care a lot about what is happening in society, but perhaps we could be more visible.
No, thank you for that. Just as a follow-up, Chief Justice, do you not think when you talk to your colleagues that perhaps there is this fear of crossing the line when you address the public in what you say? I mean, we had an example this morning in our meeting. Is there not that kind of fear of crossing the line?
No, I don't think so. Hence my suggestion that it should be structured. If it is structured, there's no fear of crossing the lines. As I said, As I said, colleagues have been doing it. We've been having public lectures, and at the end of the lecture, questions are posed to you as the presenter, and you answer those questions with the usual disclaimer that perhaps you in certain instances, you can't go far enough. But if it is structured and we all agree that we are going to discuss this particular topic, we're going to discuss, say, for example, Section 39 and so forth, I don't see how it can result in a conflict of interest, because we are all sitting there, and where we hold the view that we would be straying too far, we simply don't answer that specific question. The one thing that we do routinely at these public lectures is that when we are asked about cases that are still pending, we do not respond to those questions. So I think that's one way of ensuring that we don't stray.
Thank you very much. I wish you well. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you, Commissioner Singh. Commissioner Barnard.
Thank you, Chief Justice. As I greet you, Judge Molemela, and say good afternoon, I would just like to also say it's good to see that not only a female judge, but also a former attorney in the seat that you are now, even though it might be somewhat of a hot seat at the moment.
It is a hot seat. Good afternoon, Commissioner.
Good afternoon. My questions actually explore the application for reconsideration further.
Yes.
So the first question is to the proper functioning of that section and the access to justice aspect of it. So the question is, what can the President of the SCA do to make sure she and those involved in the reconsideration process get things right? Now, you've encouraged us with some contrary examples, but I ask this question in the light of some matters which passed through the route unsuccessfully, yet when they reached the Constitutional Court on further appeal, appeal was granted sometimes by a unanimous bench or a very large majority. So, what safeguards would you as the President build into the process to ensure that justice is done?
Yes, I think that is already being done, Mr. Barnett. The applications are entertained. I know that you, on a previous occasion, debated this with Justice Baya, and I am very much aware of the fact that the Section 17(2)F applications are being attended to timelessly, and I know this because like I mentioned earlier, just a few weeks ago, maybe 2 or 3 weeks ago, I was given that kind of application to consider because the Supreme Court, the Superior Courts Act permits the president of the court to delegate that function to another judge. So I have done it before, and I know that we receive about 3 of them per week, and I know that they are attended to expeditiously. And I have seen a judgment of the former president, Deputy Chief Justice Maya. I've seen a judgment written by her where she was refusing the application and gave reasons for her decision. So from my point of view, we are dealing with it well, Mr. Bernard.
Thank you. My second question then relates to the duplication that the procedure of such an application entails. So there was a practice directive, I think it was around about November 2018, which entails that for such an application, the party applying must again lodge a duplicate copy of the record with a complete set of affidavits and judgment in the dismissed application, etc., etc. So now, for legal practitioners that go through this process on those exceptional cases when you have to, it's difficult to explain to the client where such exceptional, why there is this duplication in the process. So the whole matter, is with the registrar of the courts. The documents are at court already. So the question is, why the unnecessary duplication? And is this not an ideal place to institute or to make sure that the electronic process gets a good use? I mean, if everything is already there, why not allow the parties then to apply on this, for the reconsideration by using the electronic platform only?
Yes, those are things that can be considered, Mr. Bernard, but I think I did allude to the fact that we had some challenges in relation to internet connectivity and our technology. But the good news is that very recently we were assured by the Office of the Chief Justice that our bandwidth is going to be increased, and that's one of the things that we could consider doing. In terms of avoiding duplications, I don't know whether perhaps you are referring to where the application is brought but not processed and you have to bring it again. If that is the case, I did mention that if appointed, I will introduce what I referred to as a chamber book, which means that when the file is brought, it is brought by the registrar directly to the head of the court, and the registrar signs the date on which he or she gives the file over, hands it over to the president, and the president on the date on which he or she has attended to the matter signs the registrar and takes it back to the registrar, and it is hand delivered. That's a process that we are doing at the High Court in relation to certain matters like the admission or discharge of mental patients and interpleader actions and cancellation of sales in execution because of the urgent nature of those matters. So that's another, check and balance that can be brought into the system. But I do also know that the data is captured electronically, and that there's what is called shared space where the registrar's team, all of them, can see on the screen the data that has been captured in relation to matters. So with the expansion of the bandwidth, I think those are systems that will be improved.
Yeah, I think I'll conclude with that maybe, and thank you, but I think that it's simply a matter of where instead of having to, as is mentioned before, brief correspondence to again submit affidavits, which you've already done previously in the process, when you apply to President, that it can be emailed. It's just so, it can be so easy to simplify the process. I'll leave it at that. If you want to comment, please do. Thank you, Chief Justice.
Thank you.
I take it you have no further comments on that last bit, Justice Molemela?
No, I have no further comments. I've given an undertaking that once the,
Yes,
The-
okay, no,
yes.
that's fine, that's
Thank you.
fine. May I assume you may have been covered, Commissioner Ngubatobi?
Sadly, no, Chief Justice.
Oh, okay, okay, you will be the last one.
I definitely apologize
Okay,
for
you will be the last
keeping
one.
everyone up at 5 o'clock.
Okay.
Good afternoon, Justice Molemela.
Good afternoon,
And
Commissioner.
like many other commissioners, congratulations for your nomination.
Thank you, Commissioner.
I want to ask you a question flowing from the discussion you had with Commissioner Steinberg,
Yes.
specifically about the role of the Constitution in contracts.
Yes.
The tension or point of tension between the Supreme Court of Appeal and the Constitutional Court has really revolved on the role of good faith,
Yes.
reasonableness, fairness in contracts.
Yes.
The view of the Supreme Court of Appeal has, prior to the judgment of Bakhazen, expressed in judgments like Brisley, Afrox, I think it was York Timbers,
Yes.
has been that these concepts are not independent substantive grounds to invalidate or to refuse to enforce a contractual term.
Yes.
But Bakhazen seems to temper that notion. But even after Bakhazen, cases like Mohammed, Potgieter, went back to the pre-Bakhazen jurisprudence and still held that good faith, reasonableness, fairness, sometimes justice is another concept, are too abstract notions to use in deciding whether to enforce or not to enforce a contractual term until, of course, Bidika. And Bidika, as you know, produced a split outcome.
Yes, I remember.
In which there is a withering criticism by Justice Froneman and Justice Madlanga against the majority judgment.
Yes.
So against that background, what is your jurisprudential approach to the role of good faith, reasonableness, fairness, justice in the enforcement of contracts? Do you see them as independent, a substantive basis to refuse to enforce a contract, or do you see them as too abstract to be used in a domestic contractual setting?
Well, they have been taken into account in a few judgments of the Constitutional Court, and you know, on the basis of the doctrine of precedence, we are bound by those judgments. And there was the judgment that you referred to of Bakhazen, and subsequent to that, we had the judgment of Bidika, where certain views and a lot of articles have been written to say that the Constitutional Court itself is inconsistent in relation to those aspects. What we can do under those circumstances, in fact, we don't have an option. We just have to follow the majority decision of the Constitutional Court. I did allude to a matter that I did. Perhaps I should not talk about that matter because I believe it's a matter that is now before the Constitutional Court, where something was raised in relation to the contract, and the appellant in that matter argued that the element of good faith and so forth could come into the picture, but then relying on a judgment of the the judgment of the Supreme Court of Appeal that was confirmed by the Constitutional Court, we just had to follow that judgment.
Sorry, I'm trying to understand your view on this. I understand that as a judge, you must look at precedent.
Yes.
But the question is a narrow and a specific one.
Yes.
Do you see good faith, reasonableness? Sometimes justice is put into it, sometimes fairness is put into it.
Yes.
As concepts that are too abstract to apply in contracts, or as concepts that are concrete enough to apply in contracts, because that's the intellectual disagreement between the Constitutional Court and the Supreme Court of Appeal. And I'm going to ask you a final question once I've got your clarity about how you see these concepts.
I see them as concepts that ought to be taken into account. I don't think there's a judgment of the Constitutional Court that says they are too abstract. I think in so far as there has been a difference of opinion in relation to certain aspects, it has been because of the specific facts of a particular case. But speaking for myself, I have no difficulty in taking them into account as aspects that should be taken into account in the interpretation of a contract, depending on the circumstances.
Yes, sorry,
okay.
I'm sorry, because I know I've got a little time, but I still want to press you to get a clear
Yes.
answer. Can you invalidate a contractual provision because it violates good faith, or because it is unreasonable, or because it is unfair, or because it is unjust? That's the question I'm trying to get to.
There are judgments of, there's the Checkers judgment of Justice Moseneke, I think. It's an old judgment where he said good faith can be a factor to be taken, that must be taken into account. So as I said, it really just depends on the facts of the matter. But I don't think we can simply just say, well, you know, the rule is that somebody must be bound by the terms of the contract, pacta, subanda, whatever. I don't think we can simply say, well, the contract says this and you are simply bound. There are circumstances that will call for the element of good faith to feature. I may be wrong, but that is the view that I hold.
No, I don't think there's a wrong and a right answer in this, because the Concord itself, the majority found that those concepts were too abstract in Bidika, and they couldn't be used independently to set aside a contract. It's the minority judgment of Justice Froneman that says actually it's wrong to see them as concepts that are too abstract. They can be applied in a specific contractual setting to set aside a contract. But anyway, let's leave that. I want to ask you a general question. One of the views that are held by academics is that one of the reasons we have why the common law is not developing at pace with the Constitution is because of the reluctance, particularly by the Supreme Court of Appeal, to apply the Constitution in the common law. And the contractual setting I've been giving you is a preeminent example where the Constitutional.
Yes, thank you for the question. We are bound by the judgments of the Constitutional Court, Mr. Ngaitobi. So unfortunately, I cannot say to you if I am appointed, I'm going to prevail on my colleagues to adopt a particular approach in their matters. I can't do that. As I said, you know, there are a number of articles that have been written to say there was Buckhazen and Bidika is now reversing from that position and so forth and so forth. And in so far as in all the matters where the Constitutional Court has spoken, on the basis of the doctrine of precedent, I follow the decision of the Constitutional Court. And I can only say to you, my view is that there are instances where the good faith element will come to the fore, and there are instances where it cannot, and that will be my own personal decision. In my own panel during the deliberations, we can debate it, and I can decide, okay, fine, the position that I'm taking on this issue is this one. It does not mean that the other members of the panel will agree with me. We have had many matters where the presider in the matter actually ended up writing a minority judgment because the other judges in the panel who were junior to him or to her did not agree with him or her. So I can't really make that promise to say, because I'm perceived to be the intellectual leader of the court, this is what I'm going to do. I can't instruct my colleagues. I can only persuade, and even then, the power of persuasion will be only in the matters that I am involved in, not any other matter.
Thank you, Chief Justice.
Thank you, Commissioner Ngwachobi. We have come to the end of this interview, and on behalf of all the commissioners. I just wish to thank you once again, Justice Molemela, for availing yourself.
Thank you, Chief Justice. Thank you very much.
Yes, I'm sure you are relieved that now you can go.
Thank you, sir. Thank you very much, Chief Justice.
Thank you very much for availing yourself. You are now excused.
Thank you, Chief Justice, and thank you, commissioners.